Yes, sir.
One urgent application.
Yes, please hand over.
Injunction application.
Application. Huh?
Application order for turn, please hand.
The urgent application, urgent
Hand over.
application, code number 37, my lord.
30.
The date is fixed on 21st, my lord.
Hand over. We are just ये শুনুন না বলছি আজকে তো মঙ্গল application is always.
One thing may I just indicate. At last occasion, your lordship has taken up the matter on 16th of December 2024. My lord, that day, my lord, there were several defects due to which the file has been sent down to department. We have corrected the defects, and my lord, there was an FMAT number. Subsequently, an FAT number has been allotted. That FAT number, I have got the FAT number, and I am mentioning today, my lord. And there was a last occasion, liberty was also given to.
Why are you mentioning these? When I take up the matter, then mention.
My lord, there is a section 5 application.
We'll take that up. Mention that only.
That I am mentioning, my lord.
Yes.
Great.
Why do you say all these things?
Great.
Hearing your lordship.
Yes, Mr. Ghosh.
2018 appeal from City Civil Court partition suit.
Appeal, Mr. Ghosh, you are not taking up. Sorry.
I wait for something, Lord. Because difficulty, Lord.
We have to dispose of some appeals first.
Stand-on was not taking the City Civil Court matter.
Understood, but this anyway. Let us see.
My lord,
বলুন।
our case is আমাদের কেসটা FAT 230/2021
আপনার কি অ্যাপ্লিকেশন?
আমাদের এটা হচ্ছে রেসপন্ডেন্ট সাইডে আছে আমরা। তো এটা
আপনি কি কারণে মেনশন করছেন লিস্টে আনার জন্য?
লিস্টে আছে কিন্তু
কত নম্বর?
এটা হচ্ছে FAT আজকের ডেটে 72 সিরিয়ালে আছে।
হিয়ারিং
হিয়ারিং
আমরা উপরে দিচ্ছি না, কেননা হিয়ারিং সবাই যারা আছে প্রত্যেকের আর্জেন্সি রয়েছে।
স্যার আমার বাবা ডাইং কন্ডিশনে আছেন।
আমি বুঝতে পেরেছি, কিন্তু আমরা হিয়ারিং কোনো আপগ্রেড করছি না।
যে কোনো সময় এক্সপায়ার করে যেতে পারেন, এটা
হিয়ারিং আমরা আপগ্রেড করছি
চিন্তায় আছি আর কি। যদি একটু
না চিন্তা করবেন না, আমরা হিয়ারিং আপগ্রেড করছি না। কল অন দ্য লিস্ট। Thus, FA number 89 of 2023 is allowed on contest, thereby setting aside the impugned judgment and decree dated September 29, 2018, passed by the Learned Civil Judge Senior Division, Second Court at Barashat, in title suit number 46 of 2013. Accordingly, the said suit is hereby dismissed on contest. No orders to cost. Formal decree be drawn up. Can such and such are also disposed of accordingly.
Wait.
Non-prosecution?
Yes, ma'am. This is the instruction, my lord.
Learned counsel for the appellants submits that the appellants do not want to proceed further with the appeal. Push up the written instructions filed in court today in that regard be kept on record. Accordingly, SA 54 of 2023 along with Can 3 of 2024 are dismissed for non-prosecution without any orders to cost. Interim order, if any, stands vacated. Thank you.
Mr. Parthapratim Roy is appearing for the response.
Why is it happening as to be mentioned?
I tell you, Lordship, this is that matter where
That matter, child.
Mr. Rai and I was working hard. We found something, my lord, on the personal law. Right, I should be very candid. My lord, under Muslim Mohammedan law, my lord, guardianship flows if there is parents are not there. My lord, the grandmother becomes the guardianship or the custodian of the child.
Satisfy us on that, yes. Let us see.
Now, my lord,
but how do you override JJ Act?
Now, my lord, in an Hague Convention, my lord, when it was kafila, my lord, a concept in the Muslim law, where it is said that where the minor, my lord, is in custody of the biological family. My lord, I use the term biological family because the parents are not there. My lord, there, my lord, a foster care, my lord, or a support by, my lord, and third party.
Mr. Chatterjee, we don't have any object. I mean, these personal laws are there, but after the JJ Act, it's very difficult to
now, my lord, in 84 Supreme Court, I was going through, my lord. conventions, my lord, from my lord Geneva and UK conventions were, my lord, read down.
Mr. Chatterjee, do this. You put whatever is there in a brief written notes of arguments.
With consultation with Mr. Rai, my lord, we are developing a concept to save the future of the child.
We're
Let-
only thinking of that.
Yes, my lord, give us 2 weeks time. We have almost
We
done.
will. We will.
We will also prescribe a modality. My lord, what is falling from my lord
Very,
is also thinking of the trafficking issue.
Yes.
My lord, the
Yes.
trafficking issue, my lord, has been dealt by 84 Supreme Court.
Yes.
My lord,
84 Supreme Court was one of the instigations for these acts.
Yes. Now, my
This
lord,
Kara formation and all this 84 Supreme Court is the landmark.
yes. Now, my lord, 84 Supreme Court says on adoption in foreign countries. But, my lord,
There the
guardian-
focus was on trafficking.
trafficking. So, my lord, to curtail down that trafficking, the court said the guardianship is an important factor, and Guardian and Wards Act is the act, oldest act, which
No, but Mr.
safeguards.
Chatterjee, after this JJ Act, we have undergone a transition evolution after that.
Now-
So that has been taken forward and merged into the JJ Act.
That's exactly where we are stopping, my lord. If JJ Act doesn't recognize guardianship but on adoption, my lord, then, my lord, question of guardianship under the Guardians Act following the concept of trafficking, or, my lord, restricting
TWC has to
trafficking.
decide who is the guardian. That is another
My
difficult.
lord, there also, my lord, in definition, I was talking to Mr. Rai. Under the Act definition, guardianship recognized by the committee. My lord, it's not appointed.
So
Recognition.
we can think about that. So
Yes.
whether appointed guardian can be recognized.
Recognized.
Very
So, my lord, on that issue, we are
So you just make it very brief.
very brief.
Very brief and annex if you have anything to
Yes, my
add.
lord.
And
My lord,
we'll keep it 2 weeks. Give us a date. We'll keep it on that.
any time, my lord, after 2 weeks, my lord.
So today we are on 11th. So should we keep it on 26th?
Yes.
We are keeping it as to be mentioned. You just file your written notes and we'll conclude.
Good.
Very. On the prayer of learned counsel for the, we'll make it parties.
My lord.
On the prayer of learned counsel for the parties, comma, the matter be listed on March 26, 2025 under the heading to be mentioned for the purpose of filing of written notes of arguments. Thank you.
Grateful.
My lord, I tender my apology for having, my lord, filed all these applications. My lord, I had no other option but to do it because,
No,
my lord,
it has been admitted. Appeal has been admitted.
yes, it was admitted. Thereafter, my lord, the appeal was dismissed for default in Loazima, my lord, court, my lord,
All right.
because of non-fulfillment of certain requirements of my lord, documents.
Yes.
Not documents for Tolowana, my lord. My lord, what I find from the records is, my lord, thereafter a restoration application was filed by my learned, my lord.
Yeah, for the other side.
Yes, my
I'm
lord.
appealing
My
to
lord.
only, my
Thereafter,
lord,
what has happened?
10
Second,
to
second.
11, 13 only.
My lord, what I
Others,
say, my lord,
Yes, sir.
thereafter, my lord, during the pendency of that restoration application, which is still pending, my lord, all the respondents, 7 except 9 to 13, has expired. Thereafter, my lord, we had taken out substitution application without being able to understand the whereabouts of the respondents, proposed respondents, as regards the death, as well as the proposed respondents. My lord, what has happened, my lord? Thereafter, the matter has travelled before this honorable court. Prior to this, my lord, 2 other coordinate benches have taken up this matter, my lord. Honorable Justice Chittaranjan Das's bench, my lord, as his lordship then was, and Honorable Justices, my lord, Harish Tandon's bench, my lord. My lord, on that, those 2 benches considered the issues of not having the dates with regard to the death of the respondents. Hence, my lord, we were handicapped to formulate any kind of applications before this honorable court with regard to setting aside of abatements. In the meantime, we had written to the municipalities, to the panchayats. There has been scufflings between two of us, my lord, not in sense we two, but the respondents and the appellants. When the appellant number 1, who has been substituted, was murdered by the one of the respondents, and the cases has been convicted. The person has been convicted. These are the, my lord, tussles between the 2 parties. Hence, my lord, we could not have got the dates. Ultimately, my lord, we had somehow got the dates, and we have filed these applications for setting aside of abatements since it has been abated. My lord, with regard to, my lord, appellant number, respondent number 228. Lord, these applications are for setting aside of abatements as well as for section 5. since long days have elapsed, my lord. But what has happened is factually, my lord, we the appellants are in a very bad state. Why I say this, my lord? This is a suit for declaration, wherein, my lord, and suit was dismissed on the ground of res judicata. Thereafter, the appellants preferred the first appeal before the trial court, before the first appellate court. It was also thereafter dismissed. Assailing that or those two orders, my lord, we have come before this honorable court in the present second appeal.
Appeal was admitted.
Yes, appeal was admitted. Stay was granted to the disposal of the rule, and the rule was, my lord,
Made absolute.
made absolute. That what has happened, my lord, during the pendency, my lord, after this suit, this appeal was dismissed for default, the respondents before your lordships had preferred a suit for recovery of the suit property. That suit has traveled all the way to this honorable court in a second appeal, and that appeal filed by us was dismissed. But I have the orders. Probably my learned senior friend was also referred to those orders. I have the orders with me, my lord. Factually, hence I say, my lord, we are in a very bad situations. But the problem which we face is it is our residential property, and since 1991 we had enjoyed stay before this honorable court. But these are the precarious facts and situations, my lord. We had, my lord, I am before your lordships, my lord.
If you are suffering an eviction degree, then what can be done?
My lord,
Even if you substitute.
my lord, unfortunately, my lord, I say this word unfortunately, my lord, this issue which is pending before this honorable court and the list before this honorable court has not been dealt with in that order.
We can at best allow your application for substitution after sitting.
My lord, thereafter I can take necessary
restore
steps.
the appeal.
Thereafter I
do
can
that.
take necessary
One
steps.
thing I want to draw your kind attention. My lord, dismissed for default 2006. Restoration application was filed 2010. My lord, the setting asset abandonment, my lord, the file, my lord, 2024, after 14 years from the restoration application. And restoration application is filed, my lord, after the near about 4 years. My lord, there is, my lord,
But
no-
since they could not ascertain the date of the death,
And my learned senior friend
he
also,
did not
yes,
inform. You have a
my-
duty under Order 22 Rule 10A.
my lord, after my lord, no, my lord, restoration application subs yet.
Yet,
কি বলছো?
Restore only, my lord, section 5 application was served. My lord, from the section 5, I found, my lord, this is the, my lord.
First time, my lord, senior friend is making this
This is
submission.
my
My lord,
lord,
also he is appearing, my lord. এটা বলোনি তুমি আমাকে আগে।
served copies come back tomorrow.
My lord, I have the my lord, restoration applications with me. তুমি বলোনি আগে?
Only section 5.
What are
my
the
lord,
cans? Can 10611 is restoration.
My lord, can 10611 is the restoration 2010, and there are two substitution applications. That
What is the new can number of that?
my lord, that new can my lord, 2018 is the first substitution application.
No, restoration application. What is the new can number?
My lord, new can number at least to the
You don't know. এখানে তো ইন্ডিকেট করা নেই।
না 16টা
10611 কোনটা? 2 এ ব্র্যাকেটে দেওয়া নেই তো। 2 of 10
2010
কোথায় দেওয়া আছে? এখানে দেওয়া আছে?
uh, 1013 of 2018, old one, that is the first substitution.
1013 some for restoration, comma, the others for substitution, comma, for setting aside abatement, and also for condonation of delay. Full-stop. Learned counsel for the appellants is requested to prepare a chart indicating the corresponding applications and hand over a copy of the same along with the unserved applications on the learned advocate appearing for the placement number
10 to 13.
10 to 13 by tomorrow. Full-stop. Next para. The applications shall be listed next on March 17, 2025 under the same heading.
Extremely
Let us
grateful.
come back.
my lord.
We'll take one by one and dispose of
Grateful, my lord.
it the next Monday. Mhm.
Item number 6, my lord, I submit before your lordship yesterday that I made a mistake, although Mr.
Oh, that.
Ghosh submits that.
Lord, we are
He also,
defendant. Only thing has because then yesterday we got
So deceased appellant number 6 is one of the plaintiffs, one of the defendants in the court below.
yes, defendant number 3. Yes, this one number 3.
No, we are just going one by one. Can 4 of 2020 was this? Have you got a copy of the server copy of yesterday's order?
no.
That would help you because you can sort out. In the first regarding can 4, we have allowed on contest granting leave to the heirs and legal representatives of deceased appellant number 6. He was one of the plaintiffs,
One of the defendants.
one of the defendants. Mr. Ghosh and Mr. Rai, can
My
we
lord.
request you something?
My lord,
Please take out a server copy of this order dated 10th of March.
my lord.
In that, please make the corrections in pencil. And please hand
yes.
over, we'll so that
My
we
lord.
can at one go. We can.
My lord,
So when should we keep it? We'll keep it next Monday for that.
Monday.
Monday. Certain corrections are required to be effected in the order dated March 10, 2025 in view of certain incorrect submissions having been recorded due to bona fide inadvertence. Full-stop. Next para. Learned counsel are requested to hand over a copy of the said order with the requisite corrections on the returnable date. Full-stop. Accordingly, let the matter appear under the same heading next on March 17, 2025. Please do that. We'll just
My,
check with each other so that
My-
there is no
my lord, my
discrepancy. And না এই অ্যাপ্লিকেশন হেডিং এ থাকুক আমরা কারেকশন করব।
Item number 7, my lord, I am for the plaintiff respondent.
Right.
I am for the petitioner, my lord. There are two applications, my lord, one for stay and another two, my lord, can number, my lord, 2 is the, my lord, for restoration, my lord.
Some defects have not been cured.
But
Yes,
check,
my
my lord, is that, my lord, I am telling you, lord, my lord. Initially, the appeal was filed, my lord, without the, my lord, original certified copy,
Right.
which was misplaced, my lord. That is why, my lord, to save the, my lord, limitation, I filed the, my lord, the appeal with the certified copy, xerox of the certified copy. Then there was the order, my lord, within time to file the certified copy of the impugned, my lord, judgment and the decree. That was not filed, my lord. That as a result, my lord, ultimately the matter was dismissed in lodging. Now, my lord, I have the, my lord, the original certified copy as well as the, my lord, the decree, my lord. That is, my lord, I have filed the, my lord, application for restoration.
That was the only defect.
That
My
is the
lord,
only
that
defect.
judgment and decree is not filed before the, my lord, office of the, my lord, register. My lord,
That was the only defect. Judgment and
that
decree.
is only defective. But my lord,
We'll
this
take that
matter-
on record and allow the restoration. Why? For this
Yes, my lord,
technical
I have
reasons.
got
why?
Yes, sir, restoration application may be allowed. Let it be heard, my lord, under order 41 rule 11.
Yes,
For
we place it
admission.
under order for
For
absolutely.
admission.
Yes. The application is can 2. What
Can
is
2.
what is can 1?
Can one of the
Can
stay
one is
application.
the
Oh,
stay
that we'll
application.
hear later.
My lord, one thing, my lord,
Yes.
title execution case is running since the year 2014. And my lord, that is
We'll
stopped
decide
during-
whether it runs faster or it stops after we hear the appeal under order for turnover.
Yes.
Can 2 of 2023 is an application for restoration of the appeal, which was dismissed in Lozima on July 6, 2023 for non-filing of the certified copies of the judgment and decree of the trial court. Push up next para, learned counsel for the appellant petitioner submits that the appellant petitioner has been able to obtain the copies thereof. In the meantime, full stop. Accordingly, comma, upon hearing learned counsel for the parties, comma, can 2 of 2023 is allowed, comma, thereby restoring the appeal along with the connected application to their original file and number, and recalling the order dated July 6, 2023, passed in the said appeal. Push up next para. The above order is subject to the. You are ready with those now?
Yes.
I was subject to it. The certified copies of the judgment and degree of the trial court filed today be kept on record. Pushed up. Learned counsel for the. No, you also have to provide second judge's copy.
Well, in the course of this, my lord, I am filing.
আচ্ছা তাহলে ওটা আর kept on record না the certified copies of the judgment and degree of the trial court shall be filed
Well, it is here. Yes, it is here.
the certified copies of the judgment and degree along with photocopies for the honorable second judge's copy দেখে সাবধান পড়ে যাবেন and are kept on record. First of next para, the appeal be placed in the list under the heading order 41 rule 11 tomorrow.
Subject to that the can one stay application has not been served. Let it be admitted after that it.
No, you serve a copy, please.
Can one application.
Serve a copy right now. Can one.
Can one application?
Can one. Immediately after the appeal, we will take up the can.
Can two is disposed of.
I shall, my lord, serve a copy.
We're not recording anything, please serve a copy.
Yes.
Serve a copy today so that he can come prepared tomorrow.
Not tomorrow, my lord, next Monday or my lord, or anytime, my lord, under 41.
That be placed in the list under the heading order 41 rule 11 tomorrow na kore on March 17, 2025, Monday.
Can two-টা দিতে হবে না তো ফোন নাম্বারটা তো আমি দিয়ে দেব
Can one.
Can one টা
তো dispose of হয়ে গেল।
দিয়ে দেব লিখে দাও
Can one.
Can.
ফোন নাম্বারটা
Yes. Yes, Mr.
What application?
Stay of operation. What is the appeal against?
Appeal against
ঠিক
the
আছে যাও
order passed by
Compensation, enhancement.
enhancement, and initially we have filed a writ application on the background that 2001 the land was acquired. Thereafter, my lord, 2002 it was handed over to the WBACPCA. At relevant time, it was the West Bengal State Electricity Board. There was, my lord, 2010. We commissioned the transmission system there. Thereafter, in 2021, we received a letter from the Additional District Magistrate LA Land Acquisition for furnishing 2.5 crores. Therefore, at that point of time, we challenged that order and filed a writ petition. That writ petition was disposed of.
Mr. Rai, have you paid the admitted amount to them?
Yes, initially
It was paid.
67 lakhs we have deposited.
So you have to deposit this enhanced amount as a condition of stay then.
My lord,
Was never informed.
Yes, this is virtually against the money degree.
yes, my lord, that's why, my lord, we challenged that and the honorable court passed an order. It is in the stay application,
Yes,
page 15, my lord.
right.
Judgment. They have converted that writ application to the appeal. And
You have filed a formal memorandum.
there is a direction to treat the writ application as a.
No, then also you have to file a formal memorandum of appeal. Just copy pasting the grounds there. Will direct you to file a formal memorandum of appeal because otherwise the appeal would not be informed.
And that further direction that the state also filed an appeal. They have not taken any step.
No, we are bothered with your appeal only because that is before us. So your certified copies of the judgments and degrees of the court below, the orders of the court below are annexed to the writ petition. We'll give you liberty to take back those copies and to annex those to the memorandum of appeal. You'll file a formal memo within a week. Can you file it? You have to copy paste the grounds.
There is 29 appeal matter. There are.
We'll give you how much time? Tell us. We'll give you 3 weeks time. 3 weeks time. We'll fix the application after 3 weeks. There are several applications.
Yes, my lord, there is several applications.
From which
one application was appearing today. There is total 29 application we have filed.
No, then we can pass an order only in respect of
In
this one.
respect of this one.
And you can file, you can prepare the memos of the others also.
Yes.
In the meantime, we'll direct to right now. When we take how soon can you do that? This one, or should you keep it after a few weeks so that you can mention the rest also in the meantime?
Because my lord, in the language of the order, my lord, that I have, my lord, that premise the writ petition be treated as an appeal under section 54 of the Land Acquisition Act.
No difficulty. We are treating the writ petition as appeal. Therefore, there is no. It's not hit by time limitation. But you have to file a formal memo of appeal.
Memo of appeal, my lord. In 29 cases, we separate memo of appeal. We shall file, my lord, and we give.
So when should you keep this application? Tell us.
Within 3 weeks.
Very well. But you have to be prepared to deposit that money when we take up the stay applications, because that is the usual. It's a money award, so you have to deposit. It will be with the registrar.
Deposit, my lord, in respect.
Otherwise, there cannot be any stay.
In respect of, my lord, we have secured by way or any other way, bank guarantee or any other way, because we are the company incorporated on the Companies Act. It is a government enterprise, my lord.
True, Mr. Rai, but the difficulty is because otherwise, if you furnish bank guarantee, that the interest won't be accrued on that. And if they win this appeal, if you lose the appeal, the land owner wins, then she'll be deprived of the interest. So if you want an order of stay, then we have to directly deposit.
We have that
We'll
is the
get
problem.
back the
Yes, difficulties in this, my lord. In the meantime, when order was passed by the executing court, they have, my lord, they have that order was, my lord, directed to furnish the principal bank account. That's why, my lord,
No, you have deposited or not?
we shall, my lord, deposit, but some but bank account should not be at in the 3,000 employee of ours.
Your bank account has been what? Attached?
They, my lord, if we fail to obtain stay on 24th March, before 24th March, the bank account will be attached. That is the order. Therefore,
Then we cannot keep it later than that. Then 17th we are keeping it next Monday. At least regarding this appeal, do that. The file a memo.
Though there is, my lord, direction to show cause, we have already taken steps to file a show cause.
What is the awarded amount in this case?
My lord, they 2.5 crores they have, my lord, asked for. My lord.
The enhanced amount is 2.5 crore.
Yes, ma'am.
After deducting the enhancement is 2.5 crore.
Enhancement is
over and above what you have paid on.
Yes.
So we can dispose of this. No, you have to serve copy on the other side.
We have already, my lord, served upon the other side. And
was there a direction?
No, there is no direction.
Without a direction, service does not mean any. Serve and come back next Monday. Serve quickly. Without direction, there cannot be any proper service.
But private respondent, we have served it, but it has been returned with the endorsement address, insufficient address. But we have address from that memo of.
No, you serve again and come back. We'll give you 1 week's time for that. We'll keep it on 17th, not 17th, on 19th.
Instead of 19th, well, can be 24th.
24th, yes, but since you said that 24th is a date given by the executing court, you can tell us, tell the executing court that you have mentioned. Initially, a writ petition was preferred against the impugned award of enhancement. Full stop. What is the date of the order? April 8th or 3rd? It's illegible now. Writ court order.
Writ court order.
By an order dated April 8, 2022, the writ court had directed the writ petition to be treated as an appeal under section 54 of the Land Acquisition Act 1894. Pushed up. Next para. Accordingly, the appellants are directed to file a formal memorandum of appeal, for which purpose liberty is granted to the learned advocate on record for the appellants to take back the certified copy annexed with the writ petition and to annex the same with the memorandum of appeal. Full-stop, such memorandum shall be filed on the next returnable date before this court. Full-stop. In the meantime, a copy of the stay application shall be served by the appellants on the respondents indicating that the application shall be listed next on March 24, 2025, when an affidavit of service shall be filed to that effect by the appellant. Come back on that date, Mr. Rai will pass our order.
My lord, for the appellant, my lord, seeking not today, my lord, my senior is engaged in a different court, my lord.
On the prayer of the appellant, the matter is adjourned for the day. Give your name, please. Respondent.
I'd like to appear on behalf of the respondent, my lord.
Yes, Mr. Chatterjee, what is the matter?
Alimony, my lord, application. Suit pillar is for divorce.
Mr. Chatterjee, can you please take the microphone a bit? Yes.
The suit pillar is for divorce.
Right.
My suit pillar, which was dismissed pillar on the ground that I wasn't able to prove pillar that there was an assault on me. But the other part,
There was
there was an assault on me, my lord, which led to cruelty. And my lord, the other part about cruelty and me being thrown out, desertion, there's no finding at all. But that's in the appeal, my lord. With respect to the alimony application, my lord, admittedly, the husband, my lord, is working in America, my lord, and he has disclosed his income, my lord.
You have filed your affidavit of asset?
Yes, yes.
Both of you have filed?
Yes. This is mine. Filed, sir? Already filed.
You have filed?
Yes, my lord, we have filed. The originals we have filed.
কোথায় যদি অ্যাপ্লিকেশন ছাড়া তো কিছু দেখতে পাচ্ছি না You have filed your opposition as well as affidavit of asset. We don't find it on record.
Yes, my lord. Both
What
of which
is
have
my
been
lord?
filed.
Go
with
through the
the-
records and find out for us. এটাই total record তো If they did not file, how could you file before them?
Your
Check up whether it's with you, the originals.
No, your lordship, we have. Please do let us be.
Must be with you. Because if the appellants have the appellant has not filed her
I don't
affidavit of
think
asset,
there was an occasion to file that before. There was no occasion that they could have
not have
filed it.
been.
Your lordship, what
Those are not on record also.
Your lordship, what had happened, your lordship, is that your lordship had passed orders for filing of the affidavit of assets and liabilities, and also to
Opposition, yes.
opposition and the affidavit of asset and liability, and also to serve it to the other side. Your lordship, what had happened is that we have filed it with a letterhead that there is a specific order, and we have filed it on record.
Where did you
with
file
my-
it?
Your,
Not in court.
Your lordship, on the same day at which this was affirmed, your lordship, it has been filed on the 28th.
Filed where? If it was in court, then we would have a copy of it. It's not on the file.
Your lordship, it has been filed in the file.
Where? In the department or before the court?
No, your lordship, in the filing department.
How does
Filing,
he-
why do you file it in the filing department?
How do they do that? Because this is
We don't know.
they cannot be
That's
a
not
number
possible
also,
now,
Not
no.
possible. And the
I
department
don't think
cannot
you are correct. Sorry. Department could not have accepted.
Milord, they've been he's way junior, Milord, but there's
No,
been
no.
quite a few Milord of these things happening.
No,
And
we'll
they don't
direct
see
you to pay some ad hoc amount then. We don't find any affidavit of asset on record, neither any affidavit in opposition. And if you can't furnish any filing number or entry number, we just disbelieve you that you have filed.
Your
You
lordship,
don't have any entry number, no filing number. It's not on record. How do we appreciate that you have filed? We don't find anything on record. Neither are you equipped with the filing number or entry number. Give us something.
Your lordship, kindly allows me time, your lordship.
1 week. File your affidavit of asset. Whatever you have there, just get it retyped and get it affirmed and file it. We'll give you 1 week's time.
Milord, they stealing a march over me. I'll tell you Lordship why. Milord, initially when the matter was moved, they said that they want a settlement. Milord, I'm really complaining here. They want a settlement. What happens was I sat for the settlement. I said, kindly get the client because you don't have the, if the client wants to settle, the client has to settle. The lawyer can't settle. But when the settlement started, he says that I will give you X amount of money. I said, look here, you are saying X, I'm saying Y. So we will have to come to some.
No, Mr. Chatterjee, if there's no settlement, we'll just decide the matter.
Yes, no,
We'll give them one.
What they are now do, what they then said, then I can't take a decision. And this is how Milord, the
Very well,
entire
then
matter
it's
is being Milord,
not
dragged
possible
on
to be
forever.
resolved, then we'll
Dragged on forever.
You'll
Now,
not let it
they've
drag
given
on
us a copy, Milord. May I hand over your lordship the copy of that asset? and
No,
passes an ad
not
hoc.
right now. Let them file it first.
Your Lordship, if I may, Your Lordship, if I may, Your Lordship, I am just going through the online case status as to the filing of the document.
Online case status means nothing to us. We need the
understand.
papers on record.
I understand, Your Lordship. Kindly grants me time, Your Lordship. We have definitely filed it. I understand that Your Lordship cannot believe or disbelieve me at this given point of
No,
time.
you have to file it physically.
Your Lordship, we will file it.
File it. We'll give you a week for that.
Lordship.
Get it retyped on and stamped and file it.
Absolutely. Your
Affidavit of assets filed today by the appellant wife be kept on record. Full stop. The time for filing affidavit in opposition, comma, dealing with the application, dealing with the allegations in the application and the affidavit of asset of the wife, comma, along with the affidavit of asset of the husband is extended for a week from date. Full stop. Next para. The reply, if any, shall be filed.
No, it's already ready.
No, keep it with you. If you don't have the opposition, how can you take the reply?
They've served.
The reply shall be filed within 3 days thereafter.
We don't have time, my lord. It's ready, affirmed on that day itself.
We'll file it after 3 days. We'll keep it after 3 days. 3 days thereafter, the matter be listed next on March 24, 2025 under the same heading. Come back on that date. You will file it within a week, sir. If it's the same copy, it need not serve a copy on them.
Right.
No, it's just affidavit of assets.
Will be the same copy, Your Lordship. It will be the same copy. Apologies, Your Lordship.
No, it's not apology. It's something else.
24th, let us come back.
Yes,
How can
that's
he
my
have
point.
control over?
No,
He has control.
I don't want to comment on
We don't disbelieve. We disbelieve the filing, but not him.
filing is filed by him only.
No, not the council. Council we always believe,
All right.
unless rebutted. Yes, next.
Your Lordship, this is my appeal.
This was admitted under Order 41. Oh, talk of
Lordship.
settlement.
Lordship,
Settle.
No, Your Lordship, we have emailed them our terms. They are yet to revert back, Your Lordship.
We are considering the terms of settlement.
No, your consideration has to be within a week. We cannot keep the matter pending for long. Otherwise, we'll dismiss for default. If you take so much time, on 4th of March, we had recorded.
Yes.
No, this settlement was going on from February. So we are now in February 25th. Today we are on March 11th. You decide within a week. We'll keep it after
Your
a week.
Lordship,
If you
kindly grant me 2 weeks for consideration.
what consideration?
The terms of settlement. We have received the terms of settlement. We are considering.
Consider today. Ask your client today whether if he agrees, he'll agree by tomorrow. If he does not, then forget it. We'll decide the matter on merits. Learned counsel for the parties submit that the talks of settlement are still going on between the parties. Full stop. We find from the records that this exercise has been continuing from February 25, 2025. Full stop. Hence, comma, we are unable to give further time to the parties to decide on the issue than 1 week. Full stop. Let the matter, the appeal was never admitted.
No, Your Lordship.
Let the appeal be listed under the heading Order 41, Rule 11 on March 19, 2025.
Grateful, Your Lordship.
Grateful, Your Lordship.
Article line add kar diyo. It will be open to the parties to reach a settlement in the meantime. Thank you. This will make it easier for your client to decide.
Great.
Well, I am for the respondent.
Yes,
wife.
Mr. Mukherjee.
I am for the
Yes.
husband. My lord, this is my affidavit in reply.
You are for the wife, Mr. Mukherjee?
I am for the wife respondent. To lordship,
you have an application, a supplementary affidavit.
I have an application, supplementary affidavit,
And
my
affidavit of assets.
and they have filed their
Opposition.
composite opposition as well as affidavit of assets.
And this is your reply.
This is my reply to that.
Very Yes, move the matter, Mr. Mukherjee. The application.
My lord, the marriage under Hindu Marriage Act.
So that you can take a seat. Yes.
Marriage under Hindu Marriage Act.
Right.
Solemnized on 20th February 2011. A male child was born on 1st June 2016. And unfortunately, the child is autistic. And that was one of the reasons, as my client alleges, that she was driven out of the house. Quote unquote, a defective child.
Son.
Son.
Hmm.
And thereafter, the parties are living separately. In 2020, my learned friend's client files a suit for divorce in the Court of Learned District Judge at HON'BLE, which came to be dismissed, assailing which they are before Lordship in this appeal. In the Learned Trial Court, we filed Section 24. We also filed written statement, but we could not pursue our legal remedies there because of my condition of penury. Here even,
no order was passed on the section.
no orders were
It
passed.
was
on that.
dismissed for default.
I think so. She doesn't even know what has happened. Even here, she has taken the assistance of High Court Legal Services Authority. Now, we have filed this application. Our contention is the husband, from the date of separation, that is from 2016 onwards, has not made any effort either to maintain me or my child. I am completely dependent upon my brother, who is the only earning member in my parental house. My father is there, but he is aged and he has no independent income. And as a lady who comes back from the matrimonial house in such a situation, certain domestic situations are also there in my parental house. So I had to take a nearby rental accommodation for a small amount where I am keeping with my child.
What do you do?
I do nothing. I'm a housewife.
Totally on your brother.
Totally on my brother and from my father's savings, which he assists. Now, my lord, if Lordship kindly comes to the now my prayers, Lordship will kindly take up my supplementary affidavit because that is much more comprehensive. Cantu was filed in a little hurry. If Lordship kindly comes to paragraph 8, I have narrated the requirements headwise. Lordship got it? Paragraph 8.
Whatever annex for the child, the
my lord,
school papers you have filed and
yes,
the treatment papers.
I have filed the doctor's prescriptions. Lordship kindly comes to page.
Any medical bill or anything?
Yes, yes. Lordship kindly comes to page 8 of the my supplementary affidavit.
Yes.
Lordship got it?
Yes.
Name such and such, age 4.5 years. Kindly sees this medical prescription as 4/11/2020. Unable to respond his name while calling. Parental interview was required, which only my interview could happen. Showing temper tantrums, socialization good, toilet indication absent. Eye contact fair, unable to chewing, unable to blowing and chewing, problem of hair cutting, unable to doing brushing, unable to follow up command, problem in dressing, tactile avoidance behavior present, hand flapping present, fear is fire. Then these are the advices given. Certain advices given by tactile stimulation, seasoning integration, wheelbarrow working, chewing activity, candle, all those things. Lordship, I started the therapy. In the next page, Lordship will kindly find that I started the therapy, which I could not continue.
What does the husband do, Mr. Mukherjee?
He is in Kolkata police, working as admittedly as a computer supervisor in the office of the Commissioner Kolkata Police in Cyber Cell. And I claim that he is earning about 85,000, but from the affidavit of assets, they are claiming that he earns a salary of 43,600 in contractual employment. But Lordship will show from his affidavit of assets, there he has admitted 43,600 as his regular salary, and about 43,000 as his other emoluments.
Show us from his affidavit of asset.
Lordship kindly comes to husband's affidavit of assets at page 8.
Yes.
For Government Contractual Service, Computer Supervisor, Administrative Officer, Kolkata Police Directorate, 43,600, column 1. Lordship kindly comes next. Perquisites and other benefits, the entire thing. Lordship turns the page. He says gas, electricity, water, all perquisites 43,400. So it comes up to 86,000, around 87,000. But he claims that his total.
Where are the deductions? His deductions?
His deduction he has not shown.
Has he given any income slip?
Yes, he has given. Lordship kindly comes to page
35.
No, his salary slip is at page 39. Though it is of 29th November 2024, not of the month preceding the affidavit, it shows earning 43,600. It does not show the perquisites.
Deductions are not shown here. Has he stated anywhere about the deductions?
Deductions, my lord, professional tax 200 only.
Income tax?
Income tax.
He pays separately. He has given anything to show?
Yes, IT return at page 35. Of assessment, last assessment year 24-25, where he shows his gross salary 551,700 and no deductions of TDS. It's not coming. Lordship, in affidavit of assets,
What are these deductions? Tax on employment and standard deduction?
The standard deduction is 50,000. That is usually not deducted. That is goes from the salary itself.
So that cannot be a part of his income.
No, that cannot be part of his income. And second, that 2,600, I think, is the 200 rupees professional tax which is being deducted.
So this is yearly.
This is annual.
Annual about 50,000, 52,000.
Yes, my lord. And Lordship kindly comes to his expenditure which he had shown, page 13.
So per month it comes to about
50,000. If I
per month.
Per month.
No, per month the deduction will be what?
Per month the deduction will be
4,300.
So it will
a little more than 4,000.
47,000 net.
No, it's about 43,000 deduction. So even then 44,000 net.
45,000 it comes. Then Lordship kindly comes to his expenditure at page 13 of his affidavit of assets.
Now you say his divorce suit was dismissed, right?
Dismissed.
Yes, page 13.
Page 13, he claims that he is staying in a rental accommodation, paying 10,000 rent, no documents annexed. Then household expenditure 15,000. He claims, I don't know, that I cannot dispute at this stage. But then he separately has shown gas, telephone, TV, cable, etc. And then at page 15, insurance, he says, life insurance, he pays about 5,229. And Lordship kindly turns, he has shown an expenditure of 28,966 at page 16. Extra amount paid by state government. And his total expenditure is 53,149. His income is 44,000. His expenditure is 53,000. And this he includes 28,966 extra amount paid by state government. Lordship kindly comes to page 38. What document he has produced in support of this? Lordship kindly sees page 38. The document
Of his affidavit of asset.
of his affidavit of assets.
Yes.
This is the document forfeiture of remuneration for the period 3rd February 2016 to 31st March 2016. Only one time way back in 2016 that he has shown his regular expenditure for 52 days, for 58 days remuneration which he had extra drawn. That was deducted then.
Yes.
And Lordship, then he claims that he is unwell, medical expenditure. His mother is unwell for that medical expenditure. His brother is unwell, the medical expenditure. And the entire about 100 pages medical documents have been produced. I have gone through them. Lordship kindly sees page 23 of his affidavit in opposition. You got affidavit in opposition, my lord.
Yes.
This is the ultrasonography of KUBP. Lordship got it? Kindly comes at the bottom, impression. Sonographic study reveals no abnormality.
Significant. There was insignificant abnormality.
Then Lordship kindly comes to page 31. At the bottom, impression, fatty liver. One presumes the reason for that, and that was one of my allegations.
No. Fatty liver can occur due to
Yes, but that one of the reason maybe.
fatty liver can occur due to various.
And then page 45 to 47.
For a teetotaler like you, Mr. Mukherjee, it may mean only one thing. But for people who drink, they know there are other reasons also. 45 to?
Maybe that's no longer a virtue, my lord.
No, drinking is a virtue now.
Yes, I
Anyway,
regret.
so 45 onwards, what are these? His,
Orthopedic prescriptions way back of
regarding
2014.
his family, the rest of his family, who are unwell also.
No, for him, his own. But these are of 2014.
Let us hear him. Yes. Yes.
And Lordship, 2 more minutes.
Yes.
His mother is not dependent upon him. His father was an employee of Kolkata police and he earns a pension.
Brother?
His brother is independent. I am instructed that he has got political influences there. He acts as a developer. And he's self-employed. And he's 42 years old. Claim is he is epileptic. These are my humble submissions, Lordship. Lordship has seen my detailed
Yes, here, Mr.
expenditure.
Datta. Yes. Yes, Mr. Datta.
Well, I'm troubled with some of the points he has made. That has to be cross-checked, my lord, because the points, my lord, the 28,966, the expenditure which has been shown, and the, my lord, the income. My lord, first make a submission on the.
Why do you cross-check? You have the
No, my
papers
lord, I
with
have
you?
cross-checked, my lord, because there is some mistakes. Apparent mistakes are there, my lord. I can see, my lord.
We can see two things. We'll be very specific.
Yes, my lord.
43,600 is your admitted salary.
Yes.
43,400 you are getting as perquisites.
Yes. No, my lord. That is, my lord, the difficulty.
Tell us why not.
I cannot show, my lord. There's a simple mistake. It has written the same thing. My lord, my junior might have mistaken that the same has been written. It has to be as.
No, it's not the same. It's 43,600 and the other is 43,400.
Yes.
It's on
my lord.
oath.
Yes, it's on oath, my lord. Only difficulty, my lord, it has to be the same one. Otherwise, my lord, the net salary which I have annexed, my lord, that is admitted fact.
Perquisites are not shown in salary. Holiday expenses, pre-concessional loans. It's very specific, Mr. Datta.
Yes,
not
Lord.
just a wayward comment.
No, it shouldn't
The
have
head
been
said,
filled up.
no, it's under a specific head, perquisites and other benefits, including accommodation, cars, automotive, sweeper, gardener, watchman, personal attendant, gas, electricity, water, interest-free or concessional loans, holiday expenses, so many things. Mistake of a junior, don't put it on your junior.
I'm putting it on.
First
junior.
of all, put it on yourself.
Yes.
And why on yourself also? Put it on your client because he earns this amount.
Yes. No, my lord. I say, my lord, kindly see the 43,400. Kindly see serial number 1 of part 4, the statement of income. That is, his net salary is 43,600.
Yes.
And 200 my lord is prerequisites.
200, forget. We give you the 200.
My lord, 43,400.
It's under the head perquisites. It's a different head.
It's a different head. It shouldn't have been.
No, you cannot have.
Well, because there is no state.
Should have grown wiser. You should have then filed a supplementary affidavit or given an advance copy to them. At this stage, at the hearing stage, we won't permit you to change this. Sorry.
Well,
You have an autistic child. You have to take care of him.
Well, that is, my lord, on
The wife earns nothing. She's hand to mouth. And your brother and your mother can take care of themselves.
No, I have annexed the
Everybody's
documents
mother and brother
than-
become sick when they have to pay alimony.
That
So
is
we are
my lord.
aware of that. So let them fend for themselves.
But my lord, the income
Your total
is, my
income
lord,
we find is around 87,000, including the perquisites. And after that deduction of
kindly
44,
see, there is no document we have annexed.
that's your
We
problem.
couldn't have.
That's your
We
problem.
couldn't have.
Perquisites, what documents will you annex? Perquisites are not shown.
Not sure, my lord, because I don't receive.
If
my lord.
Kolkata police starts to show perquisites of their people, then it will be very difficult
It is true.
because our money is also there.
That is true. My lord.
It's not a general comment,
That is true.
but
my lord,
it's difficult. It's we're not so gullible that you don't have any perquisites. The carpets of the CP office is much, I mean, better than any Supreme Court judge's office. Do you know that? But this is hearsay for us. So let us not go on this. We have 44,000 is your net income. 87,000 minus we have given taken out that 43,000 because obviously we were spending that. So 44,000 out of that, around 1/3 comes to something around 14,000. 14,000 for the wife, 6,000 for your autistic son, 20,000 per month you pay to. You expected more.
No.
You should increase a bit.
Not at all. My lord, he my lord, might kindly see, my lord, she has claimed that I
Your
earned
claim is
85,000.
35,000 for both of you. We cannot exceed that. We'll grant a 35.
No, 35,000. Because my lord, 43,000 is his net income. He has a loan also, my lord, 10,000 loan. I've annexed that document also.
Loan is not a standard deduction.
My lord, no, because I eventually I have to pay, my lord. And suppose, my lord, only, my lord,
Beg
this.
still borrow.
Yes, my lord.
Beg still borrow. Language not of us, wiser heads. That principle is still standing.
Lordship, my lord.
If she was with you, with the autistic son, you would have to pay this amount, sir.
Yes,
You would
my
have
lord.
to pay this amount.
But, my lord, she left
A
long
lady,
time back.
a lady,
And my lord,
a lady is not even entitled to rupees 14,000 per month. What do you pay to your driver, sir? What do you pay to the domestic helps in total? Have you ascertained? Go and ascertain from your whoever is in charge of your home. 14,000 per month. For a lady, the stature has to be commensurate. You are a computer supervisor with the Kolkata Police, the commissioner's office.
no, that is a
Her heart stature has to be commensurate with you. 14,000 per month we are granting. This is a pittance. And 6,000, what will she do with that? She should treat her son with that 6,000 per month. And he's suffering from autism. Come on. So it comes to 14 plus 6, 20. He asked for 35. We are not granting 35. Because you can't pay that. 20,000 will definitely grant.
See the breakup of this thing at.
Yes, but we have to balance the conveniences. 44,000 is what we find from taking your estimates. 44,000 is his income. We cannot exceed 1/3. That would be a bit too much for the wife.
1/3 normal circumstance. But
No, under abnormal circumstances, 1/3, under normal circumstances, 1/5.
No,
So the rule of thumb is 1/5 to 1/3. We are taking the highest, 1/3. And we are just breaking up the heads, 14,000 for you, 6,000 for the child. You may adjust within that. What is the date of filing of this application, Mr.
But it was on 3rd August 2023.
Why didn't you file earlier? The appeal was filed in 2022.
This was
We should grant it from the filing of the appeal. This is a legal aid case. What is the date of filing of the appeal?
it was filed
Mr. Doctor, you will know what is the date of filing. We will also check up from order.
22, numbering is 2022.
Let us check up. 4th of November 2022. 4th November 2022. So from November 2022. You are granting that. 14.6. Heard learned counsel for the parties, full stop. Upon going through the materials on record placed before us, including the affidavits of assets of both parties, we find that the petitioner wife is in dire straits, DIRESTRAITS. Insofar as her financial condition is concerned, full stop, she is at present dependent on her brother and the paltry finances available from the savings of her father. More importantly, the parties have an autistic son who is being brought up by the autistic kotha deben na. Parties have a mentally challenged son who is being brought up by the wife. The son is about 8.5 years old. Next para. Ample documents have been annexed to the affidavit of assets of the wife to indicate the huge expenditure incurred for the son on a regular basis for his treatment. Next para, the appellant / opposite party / husband has taken a plea that he also has to pay for the medical expenses of his brother, within bracket, who apparently is self-employed, bracket closed, and his mother, within bracket, who earns from the pension of the appellant's father. Hence, we do not accept the contention of the appellant that he has to spend money for the medical expenses of his family members. Next para, the husband is a computer supervisor working on a contractual basis with the Commissioner of Police, Kolkata, in the cyber cell. Next para, from the disclosures made in the affidavit of assets of the husband, we find that his monthly income is about rupees 43,600 and his perquisites and other emoluments amount to rupees 43,400 per month. Although, at the time of hearing, it is submitted by learned counsel for the husband that the quantum of perquisites was incorrectly shown, in the absence of any previous attempt to file any application for correction of the same and or any prayer in that regard, we refuse to grant the liberty to the husband to change stance from his sworn affidavit of assets at the hearing stage. Next para, in any event, full particulars of the perquisites and nature of emoluments have been stated in the affidavit of assets against the amount of rupees 43,400, and as such, we are unable to brush aside the quantum to be a mere arithmetical error. Taken together, the salary of rupees 43,600 per month coupled with the perquisites of rupees 43,400 per month brings the income of the husband to around rupees 87,000 per month. A rough estimate of 1/3 of the said amount would come to around rupees 14,000, which we decide the wife is entitled to as her alimony. For the son, although he requires much more than rupees 6,000 per month in view of his disability, keeping on balance the take-home income of the husband and the requirements of the wife for herself and her son, we decide to grant an amount of rupees 6,000 per month for the son. Accordingly, can 1 of 2022, can 2 of 2023 is, arekta line add kori, keeping in view the fact that the respondent wife is litigating through the legal aid services, comma, which clearly brings out the indigent condition of the wife, comma, we find no reason to deprive the wife of alimony from the date of filing of the present appeal by restricting it to the date of filing of the application, comma, since we can very well understand the hurdles which the respondent wife had to cross even to reach the corridors of this court through the legal aid services. Full stop. Accordingly, Can 2 of 2023 is allowed on contest, comma, thereby directing the respondent stroke opposite party husband to pay an amount of rupees 20,000 in total, within bracket rupees 14,000 for the wife and rupees 6,000 for the son, bracket closed, per month as alimony pendently to the respondent stroke petitioner stroke wife. Full stop. The current payments, comma, starting from the month of March 2025 shall be paid by the last day of each current month. Full stop. The arrears from November 2022, comma, that is the month of filing of the appeal, comma, till February 2025 shall be paid in 6 equal monthly installments, comma, the first of which shall be paid by the end of March 2025 and thereafter, comma, the next installments by the end of each succeeding month. Full stop. Next para. Have you got any bank account? Give the details.
There was one bank account near my matrimonial home only.
Will it help you if the payment is made online? Otherwise, there will be allegations that you are not receiving. They will be tendering. You will be refusing these allegations.
Take that account and give it to my learned.
Can you do that? I mean, does she have an account? Must have an
She
account.
has an account. I inquired.
Otherwise, ask her to open a number.
Last time they paid in that account.
Very well. But furnish details of the current account. You will do that by 2 days. The above payments shall be made directly by way of online banking transfer to the account, comma, to the account of the respondent wife, comma, the particulars of which shall be furnished through the learned advocate for the respondent to the learned advocate of the appellant husband by March 13, 2025. No response.
One thing, Millard, kindly. Yes.
2 tranches.
We'll adjust that. We'll adjust that from
order.
Another thing, kindly, Millard, record my submission, Millard. I have objected to the, Millard, my parents receiving the pension. My mother receiving the pension, Millard, that I have just objected.
Whatever objections are. It is made clear that the amount of rupees 1 lakh which has been paid to the respondent by the appellant by way of ad hoc payments by virtue of the orders of this court shall be deducted from the total arrears payable by the appellant to the respondent. Next. Thank you. আপলোডিং এর সময় হবে কোর্ট হবে না না হ্যাঁ হ্যাঁ yes
Lordship, learned advocate Partha Pratim Rai is appearing on behalf of the appellant's lordship. He is on his legs at court.
no
Number 6.
on the last occasion we granted
Yes,
adjournment
Lordship, kindly.
no
Short
you have to move the matter. No, move the matter right now. Sorry, what is the application for?
For recovery of khas possession.
Right, first person on the ground that you are a trespasser.
Yes, Lordship. But
Trespasser.
But I am a tenant of under Rajlakshmi Niyogi, who was the erstwhile owner of the subject property.
That is your
here.
case in the appeal. That will be hearing in the appeal. But this application is for stay of what? The judgment and degree.
When it comes to the opposition, page 39 of
You are enjoying any interim order of stay? That will be subject to occupation charges.
Yes, ma'am. That is why I'm.
So what is your name, please? You are Sengupta. Ms. Sengupta will hear him first because he will be arguing on the occupation charges. He will be replying. Yes, please take your seat. Ms. Sengupta, yeah,
To page 39 of my opposition.
right.
Market value of the property.
Yes.
44,54,104.
Market value, market rent we have to assess.
It is, my lord, the 2017, my lord. This.
Where is that? Where do we find that in this page? Because the market value is for sale.
My lord,
This is the valuation report by whom?
my lord, at the time of registration, my lord, 2017, my lord.
When you purchased.
Yes, my lord. Now, my lord, I paid for 40,000 on the ground, my lord. They are using the.
No, let us first see this. Where do we find the monthly rental assessed here? Oh, this is the market value. This cannot be a basis for calculating.
Now, my lord, they are using the property for commercial purpose, and it is on the main road at Shampoo under the Shampoo police station, my lord, which is nearby Shambhaja. My lord, kindly comes to page 4.
What business are they running from there?
They are doing, my lord, embroidery business over there.
Acha, does this open up on the main road or is it in the interior?
On the main road, my lord.
Can we find it from the
Shop is there.
top, no? Opening up on the main road. Yes.
Hello.
Why 40,000? You have annexed some other contemporary what? Any other rent receipt in the area?
No, my lord. That is not there, my lord. What has happened, my lord?
What is the area of this property?
The under Shampoo police
Area
station,
measurement.
area is, my lord, 650 square feet, my lord. Page 6 of my opposition, my lord. One big room with one covered veranda and one bath cum privy on the ground floor, along with a portion of common veranda.
Page.
Page 6, my lord. Last paragraph. 4A, 4A1 and 4A2.
Yes. What is the oh, they did not pay any rent. You were saying they're trespassers.
Now, my lord, kindly comes to their reply, my lord. Page 4.
Yes, page 4.
Paragraph 6, my lord. The
Yes.
relevant part is on paragraph page 5, my lord. They said, my lord, they are using this portion for residential purpose. Now, my lord, kindly sees these orders passed by the coordinate bench of this honorable court, my lord, in
Give
criminal.
her copies also.
Yeah. In criminal case, my lord, where they paid for relaxation on the ground that they are running a business over there and that is used for commercial purpose.
What was the occasion for the criminal case? You had lodged a complaint, must be.
They have beaten me up. My hands were broken. Both the hands were broken. Legs were broken. My lord. I have annexed the FIR, my lord. In fact, my lord, I have lodged another general diary instead of the, my lord, direction of this honorable court, my lord. My lord, they are entering the suit premises again and again, my lord.
By virtue of the order, condition of the bail, they are not permitted to enter even.
Yes, my lord.
Then they cannot run a business there.
Yes, that is why.
How can they pay up 40,000?
That is why they paid for, my lord, relaxation, and subsequently it has been.
Relaxation was granted.
Yes, my
They
lord.
have been permitted to go there.
Yes, my lord. For the purpose, only for the purpose of to run the shop.
Where is that?
My
Acha, here. The next page. Permitted to enter is. That's not stated here. Relax the conditions of bail. Paragraph 4 of that order says permitted to enter the jurisdiction of Shampukur insofar as condition they report. So they're permitted to enter. Unfettered entry. So they can enter their house.
To run the shop only, man.
To run the shop, yes. Now, why didn't you disclose this in your, you have annexed this?
My lord, this order not annexed, my lord.
But where have you stated?
My lord, page 7, my lord, paragraph C, 4C, my lord, page 7.
Yes. No, you have stated that.
Yes, my lord, they are running embroidery shop. My
But
lord.
that is different. Not about the bail. This. Anyway, they have obtained the bail, so they cannot deny property. into 650 square feet যদি 20,000 স্কয়ার ফিট ধরে তাহলে 13,000 কমার্শিয়াল এরিয়া তাহলে একটু বেশি রোড আছে 20,000 এমব্রয়ডারি শপ খুব বড় হতো না দেখি নামটা 40,000 ফিট আছে বলছে
My lord, in their opposition,
40,650 স্কয়ার ফিটের কত হচ্ছে 1,200 per square feet. What is the market rate of the per square feet there for sale?
Commercial.
If it's 650, 40,000, how did you, what was the basis of your calculation? It's not disclosed here. Per square feet, what does it come to?
Area.
Use your calculator in your phone. 40,000 divided by 650, what does it come? $40,000 by 650.
Actually, 1.53 million.
Per square feet. ভাড়া বেশি হয়ে যাবে অবশ্য এলাকাটা মানে কমার্শিয়াল এক্সপ্লোর করছি এমব্রয়ডারি শপ মানে ছোট দোকান হবে কমার্শিয়াল তো চলছে হ্যাঁ $32,500 আসছে যদি 50 করে দেবেন 32,500 30,000 এটা একটু বেশি আপনি বলছেন 30,000 এমব্রয়ডারি শপ মানে ছোট প্রহিবিটিভ হয়ে যায় Yes, what do you say, Nishan Gupta?
Lordship,
You have admitted it's an embroidery shop.
what my point is about the measurement of the 650 square feet, Lordship, and as regards my occupation in the entire property, I am occupying only 2 rooms in the entire property, Lordship, and that since very past. And I am paying due rent before the
No,
owners.
while granting stay, we have to check the current, what the market can fetch for them. If they rent it out today, that is the test under order for 205, which you know, Akhtaram's case and all the cases. So therefore, we have to see the current market rate for fixation of occupation charges for the purpose of condition of stay.
But
Your old rent, forget that. What is the area according to you measurement? 2 rooms means 650 square feet, it must be around that. And the area is very lucrative. And you are running an embroidery shop, you have admitted before,
Lordship,
contrary to your claim here.
Lordship, running 2 sewing machines and selling some.
But you have suppressed that. Why shouldn't you draw adverse inference against you? You are saying that it's a residential shop. You have stated that in your affidavit. But that has been belied by this bail, your statement before the bail court. So therefore, since you suppress material facts, why don't we draw adverse inference? We should believe whatever they are saying. That is adverse inference.
But Lordship, this is not the subject matter of the suit in.
No, but you have admitted your admission. Your bail goes. We'll record that and we'll send a copy of this order to the bail court so that the bail is cancelled. 30,000 would be a proper amount. 40,000 we won't grant. 30,000 would be a proper amount. Heard learned counsel for the parties. Full stop. From the affidavit in opposition of the respondent, comma, we find that the location of the premises is in a commercially viable area at Shampukur. Full stop. Next para. Although we do not rely on the market rate annexed to the affidavit in opposition, comma, which would be an amount pertaining to the sale of the property and not commensurate with the market rent which can be fetched by the same, comma, we find from the records that the appellant has suppressed material, appellants have suppressed material facts before this court, inasmuch as it has been disclosed that the appellants use the suit property for residential purpose, whereas from an order passed in a bail petition, in an application filed by the appellant for relaxation of conditions of bail, comma, a copy of which is handed over in court today by learned counsel for the respondent, comma, such claim of the appellant of residential user is palpably belied, since the relaxation of bail was obtained on the sole ground that the appellant is running an embroidery shop from the said premises, which is their only source of livelihood. Full stop. Hence, comma, there is no reason why we should not draw adverse inference against the appellant for such material suppression of relevant facts. Full stop. Next para. It is an admitted position that at least two rooms are being occupied by the appellant. Full stop. Next para. Keeping in view the measurement of the said room, which is about said rooms, comma, which is about 650 square feet in area, and the market rent prevailing in the location, comma, we are of the opinion that an amount of rupees 30,000 per month would suffice as occupation charges, comma, since the said amount could readily be fetched if the suit property would be rented out at the present juncture. Full stop. Next para. We also cannot overlook the fact that the property is being exploited commercially by the appellants, comma, which they sought to suppress before this court. Full stop. Hence, comma, Can 2 of 2024 is disposed of by granting stay of execution has been levied. No, granting stay of operation of the impugned judgment and decree and all further proceedings in any connected execution case, comma, if levied, comma, till disposal of the appeal, comma, subject to the payment of occupation charges by the appellant to the respondent at the rate of rupees 30,000 per month. Full stop. Now, the current occupation charges starting from the month of March 2025 shall be, now current occupation charges shall start from the month of March 2025, full stop. The said occupation charges shall be paid by the last day of each current month, starting from March 2025. Full stop. Next para. The arrears of occupation charges from the month of the impugned decree till February 2025 shall be paid in 4 equal monthly installments, comma, the first of which shall be paid by the last day of March 2025 and thereafter by the last day of each succeeding month. Full stop. Next para. Furnish your bank account particulars by tomorrow. The said amount shall be paid directly to the respondents at the respondent's bank account by online transfer, comma, the particulars of which bank account shall be furnished by the learned advocate for the respondents to his counterpart appearing for the appellants by March 13, 2025. Full stop. Next para. It is made clear that in the event of default of any of the above payments, comma, either current or arrears, comma, the stay order granted herein shall stand automatically vacated without further reference to the court. Full stop. The amount of occupation charges so paid shall be subject to the outcome of the appeal and orders passed at the time of final disposal of the appeal. The appellant shall, in view, you are appealing for all the respondents.
Yes.
In view of the appearance of the respondents to the learned advocate, service of notice of the appeal on the respondents is dispensed with. Full stop. The appellants shall, the trial court record shall be brought by special messenger at the cost of the appellants, to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants, which have liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Thank you. Yes, she argued very well, Mr. Rai. Don't be rest assured on that. It would be the same if you argued. Could have been more.
My first civil matter.
Oh, congratulations. Very, very well argued. Yes, next. 14, yes. 14 who is appearing? Mr. Rai, yes.
Yes. I am appearing on behalf of the appellant petition.
Right.
Appellant respondent number
1.
plaintiff.
Right.
And I have a preliminary objection. This application is not maintainable.
Why not?
Because Lordship kindly
What is the application for? We don't know.
Stay.
Stay of what? What degree?
Preliminary degree.
Why not maintainable?
Lordship kindly page 9 of the application. Immediate page. There is no such declaration in the, he is the authorized person to other petitioner. And in the petition, he also says that I am filing this petition on behalf of king. There is no such whisper in the amendment portion. There is no such declaration. He is filing this petition on behalf of the other petitioner.
Even one of the appellants can ask for stay.
No,
Why not? What is the bar?
because the combined petition on behalf of other petitioner.
We can treat this to be an application by the appellant number 1.
You can see the page 4. Page 4.
Yes.
The HON'BLE petition on behalf of the petitioners.
We can modify the relief and we can say that this is on behalf of only one of the petitioners. These are not objections. We'll pass the usual order. We'll record your objection. We'll pass the usual order, Mr. Rai. Final degree proceedings will continue, but no final degree will be drawn up.
That order has been passed already.
We'll continue that till this.
Yes, that, if your lordship will kindly see page 8, I suppose there is a declaration. Page 8, bottom.
Shoot for partition.
Page 8, they have both have signed. There are 2. Page 8 what?
Page 8 of the application.
What is there in page 8?
Is there an endorsement over there?
No endorsement. Or we can direct you to file and have a supplemented affidavit correcting that. Do that. You are enjoying a stay.
Right now he can.
No, affidavit portion you cannot. We'll entertain your objection. They have to file a sub. So there will be this stay application will be kept pending for some more time.
And one more. Let it be done by him, then I'll make my submission.
Yes, do that. How soon can you do that? How can you when?
In the court below, he has filed a
By Monday, we supplementary affidavit.
He'll have to file a supplementary affidavit to correct that. You're right. A preliminary objection is taken by learned counsel for the plaintiff stroke respondent number 1 to the effect that the affidavit supporting the application is not in form, inasmuch as there is no averment that the deponent, that is the appellant number 1, has been duly authorized by the other petitioners stroke appellants to file the application on their behalf, whereas the application has been described to be one on behalf of all the appellant stroke petitioners. Next para, there is substance in such contention. Accordingly, the appellants are directed to file a supplementary affidavit, including the necessary averments, to the effect that Can 1 of 2024 has been filed by the deponent therein on behalf of all the other petitioners, and that he has been duly authorized by the other petitioners to do so. Such supplementary affidavits shall be filed on the returnable date with an advance copy to the learned advocate for the respondent number 1. Full stop. The matter shall next be listed on March 18, 2025 under the same heading. Defective.
My lord,
Defect removed, yes. Defect has been removed. Move the matter.
I am for the appeal, my lord.
Yes. What is the appeal against?
I am paying for not this week, my lord.
Refused. What is the appeal against?
My lord.
You are the advocate on record.
Yes, my lord.
Then you have to move the matter. What is the appeal against? Have you served a copy of this?
No, my lord.
What is the impugned decree? Tell us that at least.
My lord, the brief is lying with a.
If you are the advocate on record, we won't grant prime. Sorry. The advocate on record has to take, you're being paid by your client. You have to take some responsibility, no? At least you should know what the matter is about.
Kindly consider, my lord.
No question of that. If the advocate on record can't tell us what the appeal is against, then sorry, we are not inclined to grant stay adjournment. Oh, money 2,40,000 কোর্টে জমা দিতে হবে।
My lord,
Very well. On the prayer of the appellants, the matter is adjourned for the day. Adjourned.
My lord, kindly note this week, my lord. The recorded the learned advocate, Mr.
Adjourned till when? Give us a date.
Supreme law is out.
When
of
should we
session.
keep it?
Supreme law is
When
out.
should we keep it? We are on 11th.
1/8, my lord.
1/8.
1/8.
1/8. On the prayer of the appellants, the matter is adjourned till March 1/8, 2025. Please give your name, sir. Advocate বললো তো ঠিক আছে দিদি। Yes, Mr. Chatterjee.
The appeal was admitted, my lord, and an interim order was granted. We were directed to serve.
What about service?
Service also.
Mr. Kormakar is appearing with you after a long time. He prefers to appear against you.
My lord, that is, my lord, my fortune. I think I should be proud of that.
What is the interim order granted? I mean,
That kindly.
ad interim injunction was refused by the interim order.
Yes, my lord. Then granted, my lord, if your lordship sees.
Service has not been affected, Mr. Chatterjee.
Restrained from transferring, alienating, encumbering, and or selling the suit property.
Service has not been affected. With what end?
That's not good service.
Left without instruction. Intimations have been. Oh, that will not.
Left now, my lord, after Justice Nageshwar Rao's judgment is good service.
We'll treat it as good service. Dispose of.
One has been served. That's the main.
Why main? This is a suit for.
Suit for declaration, my lord, that a deed executed, my lord, by somebody who had already sold it to us.
Respondent number 1 has been served.
Affidavit of service filed today be kept on record. Full stop. Since substantial service is affected, comma, we take up the matter application for hearing. Full stop. Next para. Upon being satisfied of a prima facie case having been made out, comma, at the time of admission of the appeal, comma, a coordinate bench had granted temporary injunction, had granted ad interim injunction restraining the defendant's respondents from transferring, alienating, encumbering, and or selling of the suit property in favor of third parties for a limited period. Full stop. We do not find on record any change of circumstance and are also satisfied that a sufficiently strong prima facie case for hearing of the appeal on merits has been made out by the appellant, full stop. Moreover, comma, in view of the urgency involved and the factors of balance of convenience and inconvenience and irreparable injury being in favor of grant of injunction, comma, we are inclined to extend the, we are inclined to make the ad interim order granted earlier absolute. Push up next para, accordingly, can 1 of 2024 is allowed, comma, thereby restraining the respondents from transferring, alienating, encumbering, and or selling the suit property in favor of third parties till disposal of the appeal. Full stop. The appellant shall put in requisites for service of notice of appeal on the respondents within a week from date. Full stop. The trial court records be brought by, should the trial court records? Need not.
Now, on the contrary, I was praying that this would not prevent the trial court from continuing.
Then you prepare informal paper books
I
with
will
all
do
the.
that will do it.
So, in view of the limited conspectus of the appeal, comma, the trial court records need not be called for. Push up, the appellant shall prepare and file the requisite number of informal paper books without comparing with the records, comma, incorporating all relevant documents and pleadings within, give us
A week, maximum a week.
a week.
Maximum.
Very good.
No,
No,
but
you should, our expression was too loud. You should have within a fortnight from date. Within a fortnight from date, annex these, just have them suit up. Within a fortnight from date, pushed up.
out of possession.
Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready as regards service.
Let the trial court proceed with the injunction.
It is made clear that nothing in this order shall prevent the learned trial judge from proceeding with the further hearing of the temporary injunction application as well as the suit pending before the said court.
Grateful.
Certified copy of decree of trial court, Mr. Banerjee, defect.
Number?
দেখে নিচ্ছি নেই defective degree of trial court has been filed. Defective decree of trial court, page number 1 of the decree is missing. If page number 1 of the decree is missing, Mr. Banerjee, that is the office report.
One thing. Thereafter, according to him, thereafter it was filed.
Initially, there was no certified copy.
Yes.
He filed a certified copy. Subsequent report says defective degree of trial court has been filed. First page of the decree of the trial court is missing.
But he says it is filed. If it is not filed, it can be defect, can be removed. Defect remove করে দিন যদি না ফাইল করে থাকে।
We'll grant you liberty to, but that there has to be an office report to that effect. Where is the first page? Let us personally check up. It was filed separately, must be. Trial court judgment degree. আছেন এটা তো ফটোকপি না জাজমেন্টের ডিগ্রি অবধি না আমার থাকবে এটা সার্টিফাইড কপি দিয়েছে টাইটেল সুটের দেখি লাগেছে না এটা অন্য certified copy was of the trial court. The trial court has decree. এটা তো judgment. The judgment. Decree টা দেখি. Yes, Mr. Banerjee, you can check for yourself. It starts from page 2, the covering page. এটা একবার দিন. সব সেলাই করা বেশ মুশকিল. এটা শুদ্ধই দিন. দিন. Just see the certified copy covering page, and then you just turn over, you will see it from page 2. First page of the decree is very important. So this is the copy which has been filed.
First page was missing.
He must be lying with Mr. Bhattacharya. If he's there, he must be lying. Presumption is that he lies with him unless reverted. Yes, Mr. Bhattacharya, supply that first page so that he can file. You're hauling up your client. We'll give you some time. He must be somewhere in your home.
Yes.
It transpires that although a certified copy of the decree of the trial court was filed pursuant to the defect pointed out by the department, comma, the first page of the same is missing. Push up. Accordingly, the learned advocate for the appellant is directed to file a a fresh certified copy of the decree of the trial court, comma, complete in all respects, and stroke or supply the missing first page of the certified copy thereof within a fortnight from date. Full stop. The matter shall.
fortnight কেন?
If you want lesser time, you can give you a lesser time.
Fortnight কেন নিচ্ছেন?
Within a week, Mr. Banerjee? Fortnight a week, week from date. Push up, the matter shall be listed under the same heading next on March 19, 2025, Wednesday week, 19th March.
Your Lordships, Your Lordship, a small mentioning, Your Lordship, today's item number 10, Your Lordship had taken it up, and the affidavit of asset and liability and the objection were not to be found on record. Your Lordship had directed it to file afresh. Your Lordship, I have personally gone to the First Appeal Department. Your Lordship, it has been filed on the 28th. It is lying there, but due to some inadvertence, Your Lordship, those documents have not come on record. Your Lordship has given an order to file it afresh. Your Lordship, if
we'll put it as to be mentioned tomorrow so that we can direct it to be brought from the department.
I shall.
You inform the other side.
I will.
This order will be recorded because you have passed it in open court.
Right.
What is the item number 10 টা কালকে to be mentioned দেবেন তো আজকের অর্ডারটা যেন হচ্ছে হবে it will appear as to be mentioned tomorrow. Give a notice to the other side so that you can pass that order.
Right, Your Lordship.
And you have personally checked. We are relying on you.
Your Lordship.
Very good. Don't have to touch your.
Absolutely. Obliged.
This is my appeal.
Yes, sir.
Lord, before I take your lordship, Lord, to the judgment, Lord, I have lost in both the courts below. I am the defendant in a.
Just give us half a second.
Lord.
এই আমার কাগজে যেটা নোটস ছিল সেটা চলে
But this is not the broader aspect of the matter. Now, my lord, if your lordship comes to my lord, the internal page 13, my lord, that is the not the decision with reasons
Of the appeal
court.
Stamps have been put on the page numbers.
Yes, my lord, I understand, my lord. That is, your lordship
No,
will
luckily
kindly have
30, 14 is clear, so 13 we get. Yes, this is
lordship.
yes.
Now, my lord, one of the first, my lord, the point, my lord, at paragraph 28, whether the suit is barred by limitation under Article 59 of Limitation Act or not.
So you'll be saying that since plaintiff 2 was a signatory, section 31 of Special Relief Act, therefore Article 59 applies.
Absolutely.
So
That is
let us-
clear on it. Well, that is my easiest argument to me. Because he was not one of the signatories to the partition deed.
That's an admitted position.
That's an admitted position. Because the partition deed was between Shomir Bhattacharya, Manoj Bhattacharya, Oshim Bhattacharya, Bijoy Kumar Bhattacharya, Deepak Bhattacharya, and Sushanto Chaudhary, who is the plaintiff number 2. I'm talking about Sushanto Chaudhary.
Yes.
And his mother, Mamata Chaudhary, was na? Mamata Chaudhary was the plaintiff number 1.
2 plaintiffs only.
2 plaintiffs.
Right. And the second issue was also that suit was bad for non-framing an issue on the court framed an issue.
Non-declaration of not the alleged gift deed exhibit A.
No, non-framing an issue on the point of non-declaration.
Now, if I take your lordship,
Trial court has trial court had held that it was void without framing an issue.
And Lord, that was not even prayed for.
Yes.
And the learned judge went to say, Lord, that the gift deed is an honest gift deed, non-executed, and said that because of the gift deed was void, and therefore there could not have been a consequential partition.
Why honest?
Lord, because Lord, they say that there were certain other deeds which were entered in in 1958 in a volume which is after 103 volume. It was entered in volume number 103. This particular the deed which was executed on 1958, that was also entered in volume number 103. The learned judge the opinion is that because in 103 volume there could not be so many deeds which are could be incorporated in that particular volume.
Somebody produced that volume, the extract.
I'll just come to a finding, your lordship will see how perfunctorily this have been done. 106.
Volume 106.
106.
All right.
Now, whether the trial court has compared the signature of Satyendranath Chaudhary by the handwriting expert for determination as to the fact that if the alleged gift deed exhibit A has been executed by false personification or not.
So this
whether
was also
the trial
a case.
court has exceeded pecuniary jurisdiction.
This was also their case regarding false personification.
But it was there was no prayer. First, your lordship kindly have a look at the prayer at the stay application. But let us first see the prayer and thereafter, Lord.
Prayer, there is nothing regarding the gift deed.
Lordship.
We did not find that. From the
Lordship will find that, Lord, at page 32.
As we placed, yes.
And Lord, also, Lord, that is there, Lord. It's a clear copy at page 49.
The 32 is all right.
Yes.
Yes, exactly. We don't find anything regarding the gift deed. Anyway, so this. Very well.
Then, Lord, 60B, Lord, that much.
60B is a worst.
No, Lord, that is. Whether the plaintiff number 2 was, it should be stopped to challenge the impugned deed of partition or not. So that was a question that he was, Lord. Now, Lord, let me just take your lordship, Lord, to paragraph 31. The learned counsel for the defendant contended that the suit is heeded by Article 59 of the Limitation Act for the reason that in respect of co-schedule partition deed, vide number such and such, dated such and such, plaintiff had to approach before the learned court within 3 years, such and such, from the date of execution of the alleged partition deed in question, but the title suit has been filed after long 21 years, and such belated approach by the plaintiff has rendered the entire claim of the plaintiff beyond the limitation. In this context, the case of the plaintiff as revealed from the pleading is that the plaintiff number 2 signed the impugned deed of partition Exhibit 3 at the dictation of the maternal uncle and sons of the deceased maternal uncle, with the understanding that the property is left by the father of his mother was being partitioned, and he had no knowledge that his father's property was included in the schedule of that deed of partition, and he came to know about that fact that his father's property was included in the said schedule of the partition deed before filing of the said suit. As such, the plaintiff filed the suit with the prayer for cancellation of the impugned deed.
So he thought it was his grandfather's property, or father of his mother means?
Father's property.
No,
Susanto's
left
father's
by the father of his mother means? With the understanding that the property is left by the father of his mother, or father to his mother.
No, my lord, father of his mother.
Father, grand.
These are the defendants are
No, grandfather or father to mother.
grandfather.
Yes.
Now, my lord, his case was that, my lord, this was a misrepresentation.
Yes.
That is what, my lord, he is trying to make out.
Yes.
But, my lord, when he admits, my lord, that there he has put the signature, my lord, the right to relief, my lord, ends after, my lord, within the 3 years he has to apply.
Limitation Act, a specific relief act. Yes. ওদিক থেকে কেন দেখছেন? এদিকে দেখুন। Yes. Let's continue.
From the above discussion, it is quite evident that the plaintiffs have approached before the court of law with a prayer for cancellation of the impugned deed of partition bearing number such and such dated 4/1/82 within the statutory period, that is within 3 years from the date of gathering their knowledge. Finished.
No, this is all. This is quite a bit.
Paragraph 34.
Yes, if you could, with a prayer.
Gathering their knowledge. So 59, my lord, the commencement of, my lord, the limitation is, my lord, from the date of coming to knowledge. But when a person is an executant to the deed, my lord, whether he can take the plea that it was by misrepresentation and therefore I am coming.
Limitation. Yes.
To cancel or set aside an instrument or decree for a rescission of a contract. 3 years when the facts entitling the plaintiff to have the instrument or decree cancelled or set aside or the contract rescinded first become known to him. First become known to him. When the facts entitling the plaintiff, then Lord, first becomes known to him.
No, yes, intelligent.
I'm omitting the instrument and degree and all this.
No, right. Yes. You raised a contention that trial court had committed gross error by not framing.
That is the gift deed.
But you took a contention that you did not take the plea that it was never prayed for, but only no issue was framed.
But no issue was framed because Lord, that was not prayed for.
Obviously, yes.
And here, my lord, the learned judge in the appeal court, my lord, in the decision with reasons, my lord, have framed that, my lord, that question which I just read, my lord, I. As well as, my lord, I.
But it does not frame the issue whether the gift deed was.
But
could
there
have
is
done
a
that.
finding returned on the gift deed. That I'll show before.
Yes, because the issue number II was whether the suit is bad for non-framing any issue on the point. But
That's
he does
one.
not frame an independent issue whether the gift deed is void or not.
Lordship.
He could have done that under Order of Appeal Rule 24.
He could have. And secondly, my lord, the III.
II is whether
comparison.
Signature, yes.
But until unless there is a challenge thrown.
Yes,
to the
unless there
deed,
is a
there is
an issue as to whether the gift deed is void.
yes.
But it's a question of signatures being compared, maybe. So how does he proceed with it?
Yes,
They amended the plaint.
no, plaint amendment করেন।
Para 39. Accordingly, they amended the plaint by incorporating the said
fact, but no prayer was there. That not the amended.
And they did not pray for cancellation of the alleged gift.
No.
Para 39 itself says that.
Yes.
On the ground that there is no legal existence of the said. So they can just avoid that. The gift deed of if it's 38 and 39 together means that they have incorporated that defendants in collusion with each other manufactured the alleged gift deed by false personification. That's a factual
that they
question.
have factually pleaded by amending the plaint. That is also
So
before
even
your
if that
lordship
be
for it.
so, they cannot just avoid, because the next paragraph says because there is no legal existence. If there was a collusion and manufactured, these are to be proved by evidence.
And secondly, there has to be a prayer to such effect for cancellation of a gift deed as they are asking for the partition.
No, they say that since it's no legal existence, apparently a nullity ab initio.
Then again a declaration is required.
That is there, and
then again, 58 will come into.
But there are certain line of judgments that if it's a nullity, if it's null in the eye of law, honest in the eye of law, one or two judgments, because it was cited in another case before us a few days back. Non-honest in the eye of law, then no declaration is required. But if on the basis of this allegation, collusion and manufactured, probably it cannot be said to be non-honest. It has to be proved.
But I'm just trying to give an answer to what has fallen from your lordship. But it is a registered deed of gift.
Exactly.
There is a presumption of validity of a registered instrument. The presumption has to be rebutted by the person contending that the document is an invalid or a void piece of document.
Right.
Then paragraph 40. It is my case that I am the owner in respect of 12 decimal out of 24 decimal in 222.
You rely on the gift deed and the partition.
Yes.
Yes.
The judgments have been cited.
Yes.
Then
parties having, for para 46 says, going to trial with full knowledge of each other's case. But if there is no relief sought, how can you have knowledge? That is your case.
Secondly, your lordship will kindly come to paragraph 47. Paragraph 47, the page is hidden, maybe 18.
Yes,
in the
last trial court. Is the last trial court.
Yes. In the light of the above discussion, this court being the last trial court for appreciation of fact in question and to prevent any miscarriage of justice, it seems to have done by the learned trial court, finds it is necessary to scrutinize the entire evidence brought on record on behalf of both the parties as well as judgment passed by the learned trial court, so as to decide whether in the present case any prejudice has been caused to either of the parties for not framing issue on the point of pivotal questions surrounding the legality of the impugned gift deed, that is Exhibit A. That apart, another question which falls for determination is whether the status of defendants are licensee or not has been properly determined by the learned court below, considering the entire fact of the case. After careful reading of the plaint evidence led by both the parties to the suit and impugned judgment, it appears that the Jitendranath Chattopadhyay got the suit plot number 222 by dint of settlement of deed bearing number such and such of the year 1948, and it transferred the said 24 decimal land of the suit plot number 222 to predecessor in interest of the plaintiff Satyendranath Choudhury and Harendranath Goswami. But Satyendranath Choudhury used to possess entire 24 decimal of suit land, and he died in the year 1959, leaving behind the plaintiff Mamata Choudhury as his widow, that is plaintiff number 1, Sushanto Choudhury as his son, Krishna and Ratna as his daughters, and accordingly the plaintiffs inherited the 12 decimal of suit property, being legal heirs of deceased Satyendranath Choudhury. It is pertinent to, your lordship will kindly remember, there is another Harendranath Goswami is here. It is pertinent to mention here that Mamta Chaudhary is the daughter of Satyendranath Bhattacharya and sister of defendant number 226.
Regarding the
About
devolution,
that.
there is no dispute. Regarding the devolution of it.
But they are challenging the gift deed from which, my lord, my title is flowing.
Yes, but not on the ground that the donor did not have title.
No, they say, my lord, the gift deed was, my lord, obtained by, my lord, it was a
Exactly. So the devolution of title is not in question.
No, because
I
they
mean-
are also claiming from, my lord, their father used to
Right,
possess
right,
this
right, right, right. Same set of
Same
predecessors.
set. They are saying I am owner of the 24. I say no, you are owner of 12 and not
Tax is the gift deed and the partition deed.
Then Harendranath Goswami sold 12 decimal of his share in favor of plaintiff number 2 in the year such and such, and as such the plaintiff came into possession of entire 24 decimal of land. In the light of the above discussion, it is crystal clear that both the parties to the suit had full knowledge about the respective cases, and the learned trial court had given sufficient opportunity to both the parties to establish their respective cases. From this aspect, it can be safely held that no prejudice has been caused to either of the parties. Another important question, para 42, before this court, whether the trial court properly scrutinized the alleged gift deed, appreciating all the evidences brought on record by the parties to the suit, or is causing justice to one party, injustice has been caused to the other party to this suit. Then, Lord, 54. The learned trial court, while dealing with the issue number 2 and 3 regarding legality of the alleged gift deed, Exhibit A, it elaborately discussed the evidence laid by both the parties, and thereafter the learned trial court, appreciating the evidence from all aspects, held the fact as hereunder. Then, Lord, paragraph 55. It is the case of the plaintiff that at the time of filing the instant suit, the plaintiff had no knowledge and information as to the alleged gift deed. Hence, there is no question of praying for any relief of the same. Similarly, from the written statement, I claim, Lord, that this was, Lord, the source of my title. And their contention was I had no idea about that. And yet they do not, Lord, amend the plaint after even having, Lord, amended the plaint by incorporating the fact about the execution. But they have given a go by, Lord, to the relief of, Lord, the cancellation of gift deed or declaring it as a void. In this regard, the learned trial court also considered the entire evidence of the plaintiff and the defendants for determination whether Exhibit A is a genuine one or not. The learned court will also consider that the alleged registered gift deed Exhibit A executed on 12/12/58 and the stamp paper was purchased on the same date from the stamp vendor of Chagda, and the deed was allegedly registered at the first joint sub-registry office Nodia in the year 1958 in book number 1, volume number 106, pages 92 to 94. The learned trial court also considered the documents marked as Exhibit 7 and 8, respectively. Exhibit 7 is that to say the gift deed bearing number such and such with registered.
So earlier gift deeds were, your earlier gift deed was entered into a later volume. That is the case.
Volume
1612 dated deeds were entered into volume 103, whereas your 1212 dated deed was entered into volume 106. So according to the court, that cannot happen. Para 50.
That is not the court
57.
says that this cannot happen. Therefore, there is a presumption that the deed is not a void deed. This is not the sum and substance. Your lordship is absolutely on that. But that what not the learned trial judge has said. Not that is at not the page paragraph 58
Mr.
last
Mukherjee will admit the appeal on two questions: whether the in the absence of any relief sought against the gift deed, whether the court could go into this.
Lordship.
Second is that limitation.
But limitation is the best point that I can.
Limitation is the first point.
Best point
first.
that I can.
We'll admit the appeal. The present second appeal will be heard on the following substantial questions of law. Roman 1, whether the suit, whether the primary relief sought in the suit regarding declaration that a partition deed of 1982 was, what is that relief sought? Was was fraudulent and not binding on the plaintiffs, comma, was barred by Article 59 of the Schedule to the Limitation Act, comma, read with Section 31 of the Specific Relief Act. Roman 2, whether the learned trial judge as well as the learned first appellate court substantially erred in law in declaring a deed of gift executed in favor of the predecessor in interest of the plaintiff of the defendants on December 12, 1958 to be null and void, despite no relief having been sought in the plaint against the said gift deed. These 2 points for the timings.
That's
Great.
great. There's an execution, Lord. I prayed for stay, Lord. Execution case number 1 of 2020.
You have mentioned the execution case in the prep.
I have yes.
Possibly is for operation of the order.
Execution হয়েছে তো আমি তো
No, the connected execution will also stay. We'll put in a line that and the connected
case number 1, Lord. I've read it, Lord. I'll just try to find out.
There is no question of occupation charges, Ms. Lai.
No, there is.
Unfortunately. Hard learn এরপর can 1 of 2020. In view of the second appeal having been admitted on substantial questions of law, a strong prima facie case for hearing the second appeal on merits has been made out. Moreover, in view of the averments made in the application, we are of the opinion that sufficient urgency has been made out for grant of stay as prayed in the present application. Accordingly, can 1 of 2022 is allowed on contest, thereby passing an order of stay of operation of the impugned judgment and decree, as well as all further proceedings in any connected execution case, if levied, till disposal of the appeal. In view of appearance of
Respondent number 1.
you are for respondent numbers 1 to 3.
The plaintiff respondent.
Plaintiff respondent.
There are 3 plaintiff respondents.
Right now, I have received instructions from only one of them.
You have served on the others? No.
No, she's on caveat.
Oh, till this.
I have been
caveat.
Served on the others have been served.
What's it?
No, not pro forma. The others.
There's an earlier order of a coordinate bench for the respondent to appear. So I'm just
Affidavit of service filed previously. In view of appearance of the plaintiff respondent number 1 through his learned advocate, service of notice of the appeal is dispensed with on the said respondent, the appellant shall prepare, the appellant shall put in requisites for service of notice of appeal on the plaintiff respondent numbers 2 and 3 within a week from date, service of notice on the pro forma respondents number 4 to 14 is dispensed with. Next para. The trial court records shall be brought by special messenger at the cost of the appellants, also to be deposited within a week from date. The appellants shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from date. Liberty to the parties to mention the appeal for inclusion in the list before the appropriate learned single judge having determination for as and when the same is ready for hearing.
Great.
You should have obtained Vakalana for the others also. You could have saved so much time.
try to do that.
Otherwise, the appeal would be ready for hearing. We could have direct. Anyway.
I beg to appear for the respondent in this
Respondent. You are for the appellant. Yes. 2 appeals for decree counterclaim.
No. 2 separate.
Separate. So why together?
Matter was heard together, my lord. Issues in.
Let us. Judgment of affirmance.
Yeah, reversal, not.
Reversal. The questions involved will be similar in both the appeals.
Exactly same.
What is the context of the appeals?
The defendant case is that, my lord,
Yes.
I'm starting with the defendant. I am for the defendant.
Obviously, start with yourself.
That he is in possession of a piece of land, my lord, measuring about 16 decimals since 1965. And prior to that, my lord, from 1965, he had constructed and he is occupying the same.
We hope you are not running a case of adverse possession.
Yes, exactly.
Yes.
It is a case of adverse possession. But the plaintiff has filed the suit, my lord, that he has purchased the property in the year 2001. And prior to that, his predecessor purchased the property in the year 1966 from two brothers, my lord, by two separate deeds. And these two brothers purchased the property from Jhargram paper mill. And this property originally belonged to the Maharaja of Jhargram, my lord, who settled this property by way of a registered patta in the year 1947 in favor of Jhargram paper mill.
1945?
1947.
47?
Yes.
15th August? Yes.
Now, my lord, this is the
Maharaja of Jhargram?
Jhargram. So, they are claiming title in this particular the plaintiff's case is simple, not he has paid for declaration and paid for injunction. His case is that after purchase he is in possession of the property and we are disturbing his possession. So a declaration has been sought for that he is the absolute owner of the property.
Yes.
And injunction not to disturb him. We file our written statement. And in the written statement, we have stated that we are in possession of the property since long back, since 42 years. And neither Jhargram paper mill nor the subsequent purchasers had ever obtained any possession subsequent to the transfer by way of the deed or of transfer that has been executed. Now,
they have not asked for possession from you. They claim possession and injunction.
Yes.
All right.
Now, the learned trial judge, my lord, disbelieved their case, my lord, and they said that the plaintiff could not prove the title. Several defects were there in their pleadings, as well as the evidence that has been led.
They did not produce the title deeds?
They did. And there were certain defects, my lord.
In the deeds or their evidence?
In the deeds. First of all,
yes,
the major defect that was pointed out, my lord, was that the Khatian number was supposed to be 281, my lord. And in the deed, the Khatian number mentioned was 282. That they have admitted in the plaint itself, but that has not been rectified. No deed of rectification has come for.
This is in their own deed, 2001 deed.
Their own deed, and at the same time, Lord, in their pleadings also, in the plaint they have admitted that. So no deed of rectification has come forward, and there is no effort has been made to explain the said mistake, Lord. Secondly, Lord, we have categorically stated, Lord, that we are in possession. And although how we are in possession, that has been specifically stated, we have also adduced evidence to that effect, oral evidence. But there is no discussion to that effect, Lord.
You have not produced anything to show your possession, any document, porcha or anything. But oral evidence is there.
Oral evidence is there. But
how can there be oral evidence from 1965? No witness must have been living from that time.
No, DW1, my lord, defendant himself has come forward. Only one.
DW1 himself claims to have been in possession from 1965.
1965.
All right.
So this is the case. And not only that, my lord, there are other defendants also who are also claiming to be the in possession of different parts of the property. The property consists of 9 acres of land, my lord, out of which initially 66 decimals of land were transferred, and they are claiming 16 decimals of land in the final deed, and we are in possession of 16 decimals of land. So another case has been, another point that has been agitated before the learned trial judgment was that this property is completely undemarcated. Other peoples are also there who are residing in this particular 9 acres of land. The entire 9 acres of land is being occupied by different persons. And unless the property is identified as to which is their property, which they have purchased.
In their deed, there is no demarcation boundary?
There is a demarcation,
but you say it
that cannot be identified, because this is just a piece of land, 9 acres of land.
If there's a demarcation, it has to be identified by that. Demarcation, the boundaries were given.
But from the evidence, we do not find that it has been demarcated.
From the schedule of their deed?
No, Lord. The deeds are not before me, Lord.
But those were before the court?
Those were before the court, but the learned trial judge says that were not identified. It could not be identified. If your lordship kindly takes up the judgment of the trial judge first, Lord.
But you have to produce the copies of those deeds also. You should have taken certified copies of those. Those are the basis of the.
I have instructed my client, Lord, and I could get the plaint and written statement with lot of trouble, Lord. I've got that, Lord. And as far as adverse position is concerned, Lord, while reversing the judgment, Lord, that learned first appellate court has come to certain findings, Lord, which is absolutely in contradiction to the settled principles which is now prevailing before, as far as adverse position is concerned.
What is the settled principle now prevailing?
No, Lord, if your lordship see, the learned first appellate court says that we are trespassers, we are dishonest person who are trespassing into the property.
Your honesty was also questioned.
Yes,
but
Lord.
The basis of adverse person is dishonesty.
Dishonesty, since we are usurping the property of the others.
Adverse person is usurping the property.
That is the law, Lord.
The dishonesty goes in your favor regarding adverse person.
But that is the finding.
Unfortunately, yes.
That is the finding. And that is in absolute contrast. That is the point I have taken also before your lordship, Lord. And those are the points I will be agitating before your lordship, Lord.
Let us see the appeal court's judgment.
Lord, the entire memorandum of appeal has been reproduced. Not your lordship need not take the trouble to come into that.
The order sheet also has been read. That is where the trouble lies.
The decision is with the reasons is in the inner page 8, Lord.
There was a previous suit also. 75 of 2001. Oh, this is a judgment of reversal, you see.
Yes, Lord. This is the suit.
That
was reversed.
Right. This is the relevant portion, Mr.
Lord, page 14, Lord.
Ah.
The learned civil judge decided the issues number 1. Is there any cause of action? And issues number 4, issue number 5, and issue number 6 in favor of the plaintiff appellant, meaning thereby that the plaintiff has cause of action to institute the present suit and the same is not barred by limitation and the principles of it also suggests that the defendant cannot take plea of adverse possession. Learned civil judge has rightly observed that the defendant have miserably failed to substantiate the defense of adverse possession. Defendants in one hand accepted the suit plot along with other properties were belonging to Jhargram Raja Narasingho Malla.
Civil judge has observed that you have failed to substantiate defense of adverse possession.
Yes.
So that's then that's a concurrent finding.
As far as adverse possession is concerned, Lord.
What remains?
But the suit has been dismissed.
That is itself perverse. If it's held that you have failed to prove your adverse possession, then why should the suit be dismissed?
Because he could not prove
discrepancy in his title. Discrepancy in his title.
In his title, and he could not prove his title. And he says that I have no right to.
But when you claim adverse possession means you are admitting the title of the true owner. Adverse possession is claimed against the true owner.
I am claiming the adverse possession against the original owner, my lord, not the plaintiff, since 1965. And he has
original owner means Maharaja or
Maharaja.
Maharaja is long dead.
Long dead. And he has purchased the property in the year 2000.
So now you are in adverse possession against whom? 1965. From 1965, Maharaja was dead
And
before 1965.
12 years has long passed.
No, when in 1965, at that point of time, Maharaja was not there.
But
Jhargram paper mills was there. Yes.
Jhargram paper mill was there because
Was there.
1966 was the next deed.
Yes, and they have their predecessor purchased from Jhargram paper mill.
Jhargram paper in the year 1966.
66, the very next year after you entered into possession.
So from
Their
Jhargram
predecessor
paper
was the title holder from 1966.
So from Jhargram paper mill, we are in all along possession.
From Jhargram paper mill, you are in possession against Jhargram paper mill for 1 year only. That does not create adverse possession, title by adverse possession. For that, it has to be 12 years.
Yes.
So the rest of the 11 years, you are under the predecessor of the plaintiffs.
Predecessor of the plaintiff, they did not come forward with any suit.
Then you have to admit the predecessor of the plaintiffs as the true owner. 1965 you enter, right? 66, Jhargram paper mills transfers to their predecessor. So for 1 year, there cannot be any adverse possession. You are not in adverse possession in the year 1966 when their predecessor became the owner. So from 1966 onwards, there has to be 12 years adverse possession against their predecessor. So if you say that, then you admit their predecessor to be the true owner.
We are not admitting the predecessor as true owner because they did not come forward and they did not disturb our position.
They went forward, backward, or sideward. You have to claim adverse possession. Adverse possession claim lies only against the true owner. That is settled law.
But it starts from Jhargram paper mill.
How could it? Because in 1966, Jhargram had already sold out the property.
They sold out in 1966, but we have come to possession in 1965.
In 1 year, can there be adverse possession?
No, it cannot.
So in 1966, you are not in adverse possession.
1965, we are in possession.
All along, from 1965, there are two periods. Pre-1966, post-1966. 1966, their predecessor became the owner. Pre-1966, you were there in
predecessor
possession.
also did not come and file any suit against us.
You don't understand me, sir. Even if their predecessor did not file any suit against you, you cannot claim adverse possession from 1966 onwards because 65 to 66 for 1 year, you could not have been in adverse possession. That was adverse possession, forcible possession. From 66 onwards, their predecessor was there. If you claim adverse possession from 1965 even, then the rest of the 11 years, you are under their predecessor.
Yes.
And unless, therefore, the moment you claim adverse possession, you admit their predecessor to be the true owner.
If you admit
their predecessor to be the true owner, they claim through their predecessor, then they are also true owners as per the continuation of your admission. And therefore, two things come up. One is they are true owners because their predecessor's ownership is accepted by you. Secondly, both the courts have found that you have failed to prove adverse possession. So what remains in the case?
Here comes the point, my lord.
Where comes the point?
That is
At
that,
what
that
point?
is that is what has been decided by the Honorable Supreme Court, my lord.
What has been decided by the Supreme
Court? Let me come to that point, my lord. Judgment. That whether subsequent transfer.
Yes. After you acquire title by adverse possession, then subsequent transfer. So you say before the property was transferred to
If
them.
it is behind my back.
It has to be in front of you if it's adverse possession.
It is behind my back, my lord.
What is behind your back? Mr.
transfer.
Probal Mukherjee is behind your back. Nothing else. If it's open, hostile, continuous adverse possession against, it has to be against the true owner. Open, hostile, you shout out, I am in hostile possession.
It is hostile. Definitely it
You
is
have
hostile
to open,
because they did not come forward.
Cannot be behind the back of anybody.
No, my lord. The transfer itself is behind my back, my lord. And I am all along in continuous possession.
Right.
And moreover, my lord.
But there is no proof of adverse possession, you said. No proof of adverse.
At the same time, Lord, they could not prove their title because the title itself, the transfer of title itself is defective.
How did the appeal court deal with that, the defect in the title deed? Let us see that.
In this point, Lord, I will be placing a one judgment later on.
Yes, absolutely. Absolutely. We'll look into it. Now, page 16 of the trial court, apparently, appeal court. Suit plot is very much identifiable. Raja such and such. Appeal court says that in the sale deed, area of 66 decimals is demarcated, Mr. Page 16 of the appeal court. Penultimate line of the last of the first paragraph. It's identifiable and demarcated. Vis-a-vis exhibit 3.
Not the area of 66 decimal is demarcated.
কিন্তু যেটাতে ট্রান্সলেট করছে বা পাঠটা কিন্তু তখন মৌরসি মুখারি যদি পাঠটা হয় তাহলে এর মতোই হচ্ছে মৌরসি মুখারি পাঠটা হচ্ছে আর সেটা তো চেঞ্জ করে লোকাসটা adverse possession claim for appeal court which identify that demarcated we very much identify that demarcated decisions in the actually finding and the high court could difficulty which adverse possession proof for the possession proof for there was not a single document with some regarding your possession, only oral evidence.
No, no.
If there is no document, then how could it be hostile against somebody?
If your lordship has seen this evidence, this finding, Lord.
Page 16 of the appeal court.
Yes, Lord. Now, if your lordship kindly comes to the finding of the learned trial judgment, which has been reversed. Lord, inner page 12, Lord, as per the plain case.
No, plain case, let us, what is the finding of the trial? Let us come to that.
page 14, in the middle paragraph, my lord.
Point number 2, page 21, you can directly come. That is the finding which you are relying on. Internal page 20, page 21 of the trial court. First 4 lines of page 22 says inadvertently due to pen mistake, RS plot was mentioned as you are submitting. 282.
And they have admitted also in the plaint, my lord. So that cannot tally, my lord. It belongs to someone else. Have you got copies of the deeds, Mr. Ram Kormakar? There are discrepancies in your deed. You should have brought the deeds. Rectification to sign. The deeds were filed by them, my lord. So
Obviously.
we have
you
applied
could have
for the
taken
certified copy, my lord.
That was required. I mean,
Because
RS plot number has been written as 2282 instead of.
this is the well reasoned order, my lord. The learned appeal court has said nothing. Only he has said that it has been well demarcated. How, we don't know, my lord. Rather, the learned trial judge has taken the trouble to explain everything, my lord, and he has compared everything.
So the last paragraph of page number 23, your lordship is looking into, Lord, might be of some, Lord, assistance. Internal page 23 of that judgment, last paragraph.
Yes.
I also wish to say that the mistake in exhibit 6 is not so palpable that a prudent man cannot possibly have any doubt as to what the parties to the deeds wanted to mean. Lord, the trial court comes to a different finding.
No, it's the other way around. I also wish to say that the mistake in exhibit 6 is not so palpable that a prudent man cannot possibly have any doubt.
Identifiable.
But then it says from the aforesaid discussion, it is established that errors in exhibit 6 is not an accidental slip. You ought to have filed a deed of rectification. You admit the mistake. You have failed to show any title regarding that property. How can
Lordship,
you
kindly have a look at the plaint itself.
will be compelled to admit this appeal on this frivolous ground. Otherwise, they have no case whatsoever. Absolutely nothing is in their favor except your documents.
Not the plaint itself, but they have stated.
কিন্তু এখানে বলছি সুট প্লট ইজ ভেরি মাচ আইডেন্টিফাইবল সেই জায়গাটা আমার খটকা লাগে না আরেকটা জিনিস এখানে আছে সেটা কি বলুন তো এই খাজনা দিচ্ছে এ প্রমাণ করছে প্লেন্টিফের নাম রেকর্ডেড এলার তাহলে অ্যাটলিস্ট বেটার টাইটেল তো হচ্ছে ও তো পজিশন প্রুভ করতে পারে না Mistake তো বোঝাই যাচ্ছে কিন্তু Mr. Mukherjee, only one thing, they have proved that they are paying khajna. LR records of right do not prove title or create title, that's settled. But why not they have better title than you? You have failed to prove anything to show your position. Or any iota of title, your title is based on your position because adverse possession is a title based on position. You fail to show your position and adverse possession. They have at least shown that they are in occupation by paying khajna to the government, name recorded in the LRROR. So why shouldn't you hold that they are in, at least they have a better title than you?
In that event,
So this is not a judgment in rem that
Lord,
they have to prove title
Lord, in
against the
that
whole world.
event, Lord, this suit is also barred, Lord.
Why do you say
because
that?
they have not paid for recovery of position.
No. They have shown that they are in position. They are paying khajna to the government.
They are not in position. If that be so, Lord, then they are not in position.
You have failed to prove your position in any manner.
Position nowhere discussed, Lord. Nowhere discussed, Lord. In the entire two judgments, nowhere position has been discussed.
The adverse position you have failed to prove that was.
Adverse position is different thing, Lord. They say that adverse position I could not prove because that is no
But there is nothing
element of
there is admitted. It is an admitted position that you have not. We are asking you. You are saying that there is no documentary proof of your position.
But in the written statement, I have categorically stated.
Written statement is not a proof, documentary proof of your position, Mr. Mukherjee.
But there is no evidence also that we are not in position in their oral evidence also, Lord.
How can there be negative proof that you are not in position? They have showed that their names are recorded in the LRROR. They are paying revenue to the government. Area is demarcated.
In that respect,
because although they sold it, because the finding of the trial court, if you look carefully, appeal court says that it is identifiable because from the area of 66 decimals as appearing in the deed is demarcated. Regarding the dag number, there is a mistake, but the area is demarcated fully. 66 decimals. The rest of the descriptions tally.
No, it cannot be demarcated because it is undivided. 9 acres of land. No
Those
partition.
cases you have not been able to prove.
It is admitted.
Demarcated portions were sold to them.
It is admitted that it is undivided, unpartitioned.
Where has it been admitted?
Finally, see the plain blood.
And moreover, Mr. Mukherjee, since you have claimed adverse possession, you have admitted their title. So you are at least stopped from raising the question of their title. Adverse possession means you have admitted themselves to be true owners, their predecessors to be true owners. That is another difficulty you are facing.
But as far as my adverse position is concerned, Lord, the judgment of the Supreme Court, Lord, I will be placing, Lord.
Place that.
It is a continuous one. Lord.
Place that. কি রয়েছে এই পজিশন অ্যাড্রেস পেশেন্ট পোস্ট করতে পারে প্লাস অ্যাড্রেস পেশেন্ট ক্লেম করেছে মানে ওনারশিপ ক্লেম করে ফেলছে জুডিশিয়াল হ্যাঁ না আছে না অ্যাডমিট করে 20 বছর ফেলার মতো মানে খাজিনা দিচ্ছে এলআরআর এর রেকর্ড আছে ও পয়সা প্রুফ করতে পারেনি as against him he is stopped from taking this point you to discuss করে দিতে adverse possession এর ডিগ্রি দিয়ে দিলে সাইকেল চাপা পড়া হতে হবে কেউ বিশ্বাস করবে না
Paragraph 50, 51.
Give the citation.
Another.
2019 8 SCC 729. Oh, this. There are 50-50. This is for the proposition whether a plain suit can be filed on the ground of adverse.
Not only that, Lord, limitation.
Limitation
12
is the
years.
limitation is the
And
basis
when
of
it starts, Lord.
limitation is the basis of adverse position.
And when it starts, Lord.
Place that portion. It starts from when the person becomes adverse.
And subsequent transfer, Lord. That is also another judgment, Lord.
No, this judgment first. Let us complete this judgment first.
Paragraph 51, Lord.
51, yes, we are reading that.
The statute does not define adverse position. It is a common law concept that the period of which has been prescribed statutorily under the law of limitation in Article 65 as 12 years. Law of limitation does not define the concept of adverse position, nor anywhere contains a provision that the plaintiff cannot sue based on adverse position. It only deals with the limitation to sue the extinguish of rights. There may be a case where a person who has perfected his title by virtue of adverse possession is sought to be ousted or has been dispossessed by forceful entry by the owner or by some other person. His right to obtain possession can be resisted only when the person who is seeking to protect his possession is able to show that he has perfected his title by adverse possession for requisite period.
You are relying on this also.
Understand?
He is also relying on this judgment.
Under Article 64, also suit can be filed based on possession. I'm not on that note. It is the settled, although the planet.
Yes, but why is this relevant, Mr. Mukherjee?
Which one?
Why is this judgment relevant?
Yes, no, I'm coming to that.
You said para 51. Here it was held by the Supreme Court, Mr. Mukherjee, that a suit can also be filed on the strength of adverse possession. Previously, it was only a shield.
Here,
now, in this judgment, it was held it can be a sword also.
Yes, not. It can be.
That was the principle, yes. So, if the adverse possession ripens into a title after 12 years,
file as a plaintiff.
You can file a suit that becomes title as good as other title, and that is heritable also after that ripens into title.
Yes,
that was
after.
held there.
And
but
at the
here you
same
have
time-
failed to prove possession even, let alone adverse possession.
At the same time, Lord, paragraph 60.
The paragraph 60, place it.
The adverse possession requires all three classic requirements to coexist at the same time. Namely, nec y, adequate in continuity, nec clam, that is adequate in publicity, and nec precario, adverse to a competitor, in denial of title of his and his knowledge, visible, notorious, and peaceful, so that if owner does not take care to know notorious facts, knowledge is attributable to him on the basis that due to due diligence he would have come to know.
Here there is nothing visible, notorious, or peaceful about your person. It was not notorious, not visible even, because you could not prove possession even.
I am in possession, Lord, because since 66, no one has come forward to challenge my title, Lord, to oust me.
You could not prove your possession in the first place, apart from your own oral evidence that I am in possession. Only the defendant says that I am in adverse possession since 1965. Nobody else comes up, no document to show your possession even.
And he is coming and filing a suit for declaration, and he is filing a suit for injunction that I am disturbing his possession.
He is claiming declaration of possession, a declaration of title and possession. You file a defense saying that you are in adverse possession during a period when his predecessor in interest was the title holder of the property. That means you are admitting that the predecessor was a true owner.
When the title itself is defective, Lord.
Then your adverse possession claim is also defective in that sense. You cannot say title is defective because your adverse possession claim is based on the true ownership. Adverse possession, one of the essential criteria is adverse possession can be claimed only against the true owner. That is the first principle of adverse possession, Mr. Mukherjee. You must
even if that be so, Lord. But the suit as framed, Lord. At least they cannot come and get a degree for
as against you.
As
It is
against
not a
me.
judgment in rem. You are stopped first of all because you admit their true ownership, and they have a better title because they are showing other collateral evidence such as payment of revenue to the government, LR records, their possession is recorded. So why not they can't get a declaration against you?
Because
you have facilitated that by admitting their true ownership by claiming adverse possession.
Because the chain deed that were produced, Lord. First of all, they did not produce the chain deed, Lord. Secondly, the Khatian numbers differ. That has been admitted. They themselves admits in their plaint.
No, it's obvious that the rest of the description tallies because the court says it's identifiable and 66 and it's demarcated.
How? That has not been explained. On the other hand, the trial judge says it cannot be identified.
And Mr. Mukherjee, in the other judgment you are citing? Substantial of action.
But this is non-reportable. Here there was subsequent transfers, and even after that, if your lordship kindly have a look at it.
Once possession, your adverse possession ripens into title, then you are a title holder like others. Yes, you can give a copy to Mr. Kormakar.
Yes,
he doesn't have a right of hearing, but he has a right of seeing.
Yeah.
You can read out the name, Mr. Mukherjee. The name of the parties. You have given your copy to us.
Lord, I have asked for a Xerox.
It is that judgment, the one at the bottom, not that.
No, this is
Krishnamurthy.
No, this is a different one. This is Government of Kerala versus Joseph and others.
You are focusing on South India.
Yeah.
You Which paragraph, Mr. Bhuju? How is
Not-
this relevant?
Paragraph 12 onwards. My lord.
12 onwards, yes.
My lord, 14.
This may go against you also. His name figured in the revenue record from such and such year. Presumption of truth is attached to revenue record which has not been reverted. Their name is in the revenue record, not your name. In your case.
Then come, my lord, after that. No?
After that, yes. Don't leave it to guesswork. Then we'll find out the wrong provisions. Place the portions which you want to rely on. Wherever we are looking at, it goes against you. It's very risky to leave it to the guesswork of the
net
judge.
result is that KS is not the owner of the property, but it is equally true that from 1963 he had been thrown to be in possession pursuant to the application exhibit such and such of the Talsita. This is the position was adverse to the true owner. It is openly hostile to the claim of HR and his legal representative, and they never filed a suit for possession of the property. Once it is held that KS was in possession of the suit property, the consequence will be that he is in adverse possession. The legal representative of HR have failed to show how they have obtained possession from HR. Even according to HR, it was AR who was in possession of as a tenant. AR surrendered part of the land to, so Lord, here what I am on, Lord.
Yes.
That he was in possession since 1963 and his subsequent legal representative and subsequently from whom they have acquired the title, Lord. They have also they are also claiming adverse possession against them, Lord.
Sorry, no interference. We'll give our reasons. The present second appeal has been preferred against a judgment of reversal. Full stop. Next para. The learned trial judge has dismissed the suit for declaration of title and permanent injunction filed by the plaintiff stroke respondent number 1, comma, which decision was reversed by the first appellate court. Full stop. Learned senior counsel appearing for the appellant argues that in the teeth of the specific finding of the learned trial judge that the plots mentioned in the title deed produced by the plaintiff did not tally with the suit property, comma, the learned appellate judge appellate judge arrived at a perverse finding in holding that the suit plot was identifiable and demarcated. Push up next para. It is argued that it was an admitted position by the plaintiff that the specific plot, a specific suit plot was not mentioned in the sale deed of the plaintiff, comma, for which on the said count alone, comma, the suit deserved to be dismissed irrespective of the defense taken by the defendant stroke appellant. Push up next para. It is argued that the learned appellate judge did not advert to such factum, facet of the case at all. Push up next para. Secondly, comma, it is contended that the appellant sufficiently proved his case of adverse possession from the year 1965 by oral evidence, which was unrebutted by any proof of title on the part of the plaintiff stroke respondent number 1. Pushed up as such, comma, the decision of the learned first appellate court is tainted by patent error of law. Pushed up next para. Upon hearing, learned senior counsel appearing for the appellant cites the judgment of নামটা দিয়ে দেবেন reported at 2019 8 SCC 729 as well as an unreported judgment of the Supreme Court in the matter of এটার নামটা দিয়ে দেবেন কৃষ্ণমূর্তি বলে এটা in support of his arguments. Who's up next para? Upon hearing learned counsel, senior counsel for the appellant, comma, we find from the records that no substantial question of law is involved in the matter. Who's up next para? Although the learned trial judge had observed that there was a mistake in mention on the plot numbers in the title deed of the plaintiff, comma, in the same breath, comma, it was observed that the mistake in the title deed within bracket exhibit 6 is not so palpable that a prudent man cannot possibly have any doubt as to what the parties to the deeds wanted to mean. Full stop, next para, coupled with the said finding, comma, it is seen that the learned first appellate judge categorically adverted to the said document and observed that the suit plot was very much identifiable. Pushed up, in the pleading, comma, the defendants had admitted that the suit plot belonged to one Jhargram Raja Narasingha Malla, comma, who on January 4, 1947 granted patta in favor of Jhargram Paper Mills Private Limited, comma, whose name was recorded in the RS Khotiar number 282 by 1, comma, which is the suit plot, full stop. The said Jhargram Paper Mills Private Limited sold and transferred 1.44 acres of land by way of registered sale deed on April 4, 1966 in favor of Sudhanshu Kumar Rai, comma, the predecessor in interest of the plaintiff, full stop, next para. In the said perspective, comma, the learned first appellate judge held that the area of 66 decimals claimed by the plaintiff is demarcated as apparent from the sale deed dated March 24, 2000, and as such the suit plot and as such there was no question of the suit plot not being identifiable in the teeth of exhibit 3. Push up next para. On the other hand, comma, the concurrent finding of both the courts below is that the defendant has failed to prove adverse possession as comma, which is the sole basis of the defense case. Pushed up, it is also found from the judgments of the trial court as well as the first appellate court that not a single document of possession, comma, let alone adverse possession, comma, was furnished by the defendant stroke appellant. Pushed up, the defendant stroke appellant relies solely on his own evidence to substantiate his case of adverse possession. Pushed up, next para, another aspect of the matter cannot be overlooked. Pushed up, the very premise of a claim of adverse possession is that the title of the true owner, comma, against whom adverse possession is pleaded, comma, is admitted by the person claiming adverse possession. Full stop. Even as per the defense case, comma, the defendant came into possession of the property in the year 1965 and Jhargram Paper Mills transferred the property in favor of the predecessor in interest of the plaintiff in the year 1966. Full stop. Thus, comma, within the said year of the interregnum, comma, the possession could not have been converted to adverse possession of 12 years. Push up, thus, comma, from 1966 onwards, comma, the possession of the defendant, comma, even as per the written statement, comma, must have been under the predecessor in interest of the plaintiff. Push up, thus, comma, by claiming adverse possession since 1965, comma, which incorporates 11 years thereafter when the property was owned by the predecessor in interest of the plaintiff, comma, the defendant admits the predecessor in interest of the plaintiff to be the true owner and as such, comma, cannot resile from such position and dispute the very title of the plaintiffs. plaintiff, full stop, next para, that apart, comma, the declaration of title in a suit inter se between parties, between private parties, does not acquire the character of a judgment in rem and is only binding between the parties, comma, being a judgment in personam. Full stop. Seen from such perspective, comma, the plaintiff has been able to establish better title than the defendant, comma, in view of production of documents showing that revenue has been paid by the plaintiff to the government and that the property in question has been recorded in the LRROR in the name of the plaintiff, comma, which otherwise tallies with the description of the property in general in the sale deed of the plaintiff, comma, although there was a minor discrepancy in the description of the plot number, plot stroke Khotian number. Full stop. Next para. Hence, comma, inter se the plaintiff and the defendant, comma, the better title of the plaintiff was definitely established. Full stop. Next para. Thus, comma, particularly since the defendant stroke appellant failed to prove adverse possession, comma, there is no perversity in the appellate court's judgment which can prompt the second appellate court to interfere with the same. Full stop. It is well settled that the second appellate court shall not disturb the finding of either of the courts below merely because another view is possible. Full stop. Next para. That apart, comma, insofar as adverse possession is concerned, comma, there is a concurrent finding against the defendant in that regard by both the courts below. Full stop. Next para. In the above context, comma, in the above korben na. Insofar as the judgment of Ravinder Kaur Grewal Supra is concerned, comma, the same does not inure to the benefit of the defense case in the defense case in any manner. Full stop. Paragraph 51 of the same, comma, relied on by learned senior counsel for the appellant merely lays down the law that in terms of Article 65 of the Limitation Act, comma, adverse possession for a period of 12 years tantamounts to adverse possession in law. Full stop. In fact, the moot question which was decided in the said judgment was that adverse possession can also be used as a sword apart from being used as a shield, and a suit can also be filed on the ground of adverse possession once such adverse possession is ripened through open, continuous and hostile possession against the true owner over a period of 12 years. Full stop. However, comma, the ingredients of adverse possession as indicated above have not been established by the defendant at all in the present case. Full stop. In fact, comma, in paragraph number 60 of Ravinder Kaur Grewal Supra, comma, the Supreme Court stresses the classic requirements of adverse possession which must coexist at the same time, namely nec v, NEC space VI, that is adequate in continuity, comma, nec clam, NEC space CLAM, that is adequate in publicity, and nec NEC precario, PRECARIO, that is adverse to a competition in denial of title and his knowledge. Full stop. Such ingredients are missing in the present case. Full stop. Next para. In the judgment of Krishnamurti Supra, comma, also cited by the appellant, comma, the adverse possession of the party concerned had already been proved for a period of more than 12 years. Full stop. In the facts of the said case, comma, the Supreme Court observed that the possession was adverse to the true owner and it was openly hostile to the claim of the true owner and his legal representatives. Full stop. Such ingredients, comma, however, comma, are completely absent in the present case, which is substantiated by the concurrent findings of both the courts below. Full stop. Thus, comma, we are unable to convince ourselves that any substantial question of law is involved in the present appeal. Accordingly, SAT 156 of 2023 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Consequentially, can 1 of 2023 is also dismissed. There will be no arrest to cost. For instance. Yes. Next.
So the same goes for.
Achha, what about the other appeal?
Same.
What is the difference? Plots are different.
No, the same. Only the parties are different. They're not here.
Plot is also same. Plaintiff or defendant below. Plaintiffs
Here,
are
below
defendants.
plot.
আর লাস্ট একটা লাইন করে in view of the facts and circumstances of both the appeals being identical, comma, the above judgment passed in SAT 156 of 2023 also governs SAT 157 of 2023. Full accordingly, SAT 157 of 2023 is also dismissed under Order for Rule 11 of the Code of Civil Procedure, comma, consequentially, can 1 of 2023 filed in connection therewith is also stands dismissed without any orders to cost.
So the first one is plot number 772. The second one is 79.
So not discuss the plot numbers, so no difficulty.
Discussion point.
No, you need আমি বললাম.
Can listening? What was the can for?
No, the can কিছুর জন্য
Same. কোনটা লিস্টে নেই? কোন ক্যানটাই লিস্টে নেই? ক্যান গুলো যেটা বললাম দুটোতেই ব্র্যাকেটে লিখে দেবেন, ব্র্যাকেটে না, ক্যান such and such is treated to be on the days list and dismissed. দুটোতে এটা ওর সঙ্গে অর্ডার শিট, এটা হারাবেন, এটা মেন ফাইলে।
And has been disposed of earlier. There was section.
Dispose of earlier means
Section 5 was them.
both the cans?
Yes.
Or there was no stay application in connection. Both the cans were section 5s. Can sentence say? Thank you, Mr. Mukherjee.
I appear for the respondent.
Yes. Yes, Mr. Chakraborty.
I appear for the appellant, but perhaps they have mentioned the appeal.
Perhaps?
Perhaps they have mentioned the appeal, my lord, even without serving us a notice. I don't know how.
Because you could not have mentioned the appeal. No, then.
Even they sent a notice to my client directly
No.
yesterday.
Mr. Mukherjee must have been unaware of this.
Of course.
I had no.
Must have been unaware.
Has to
You
be.
cannot mention a
Has
second
to
appeal for order for turn hearing. You don't have a right of hearing.
And secondly, my lord,
But you come prepared.
yes, I'll come to.
Since you have the misfortune of having it before us.
It's not that, my lord. Today only I got
No,
it.
come prepared.
Okay, kali kisi next week will, my lord.
Notice this नहीं करना थी.
Learned counsel for the appellant submits that the appeal was appellant submits that the appeal was mentioned for hearing under order for Rule 11 of the Code of Civil Procedure at the behest of the respondents. Full stop. However, comma, since the respondents do not have a right of hearing at this stage, comma, there is substance in the contention of the appellants that the appellants might be unaware of the listing of the present matter. So be that as it may, comma, in order to enable learned counsel for the appellants to prepare himself in the matter, let the same stand adjourned till 17, March 17, 2020. Month. Come back on that. Order for bad practice. Admit হয়ে গেলে তারপর
My lord, on the last occasion, your lordship directed me to correct the defects, but there was a judgment of the learned lower court which I obtained yesterday.
Do you have it with you?
Yes, I have it with me.
But order for turn, you don't have a right of hearing in that sense. You can file the judgment of the trial court. You have 2 copies, you have to have 2 copies.
I have got only 1 copy.
Certified copy, 1, but photocopies for my learned brother.
Yes, your lordship.
Come prepared tomorrow then.
But not tomorrow, my lord. Kindly make it on the.
That was the only defect or some other defect?
There, the second, the copy of the honorable second judge is also to be prepared.
just received the thing.
Not in form, certified copy of the judgment decree of the trial. Oh. Look at the trial. No, the classification of the appeal in the memorandum is also wrong. It cannot be like this memorandum of appeal against the judgment and decree dated such a. Has to be memorandum of appeal against appellate decree or something like that.
That has to be corrected. my lord.
Rectify. The learned advocate and record for the appellant shall rectify the classification of the appeal in the memorandum of appeal and shall file the certified copies of the judgment and decree of the trial court when the matter is taken up next, comma, along with the Honorable Second Judge's copy. When should you keep it?
17th.
17th, why?
Or before then, not tomorrow. That is, it can be taken up on 13th or 17th.
Very well, 17th then. 17th.
Okay.
On the prayer of learned counsel for the appellant, let the matter stand over till March 17, 2025.
But I appear for the apple.
Yes.
But I am a defendant who lost in both the courts below.
Yes.
In a suit for, I'm not reading out the prayer. For declaration that the defendant is a money lender to the plaintiff and the agreement dated 1/6/2006 is a camouflage one having no legal force, being an unregistered one, and has not created any interest in favor of the defendant as tenant. The defendant took possession of the suit property to secure his loan amount.
The prayer continuing.
This is a prayer continuing. The first prayer ends.
That is the pleading also, or that is only the prayer.
No, that is Lord, I am reading only the prayer. Then Lord, B is for injunction restraining the defendant. Lord, it is at page 68 of the stay application.
We are interested now.
For injunction restraining the defendant from creating any third-party interest with possession in respect of the suit property. For direction upon the defendant to vacate the suit property on receiving rupees 4,02,000 as per calculation from the plaintiff, or by encashing the fresh check alternatively for recovery of possession of the scheduled property through court on deposit of 4,02,000 in the name of the defendant in court for recovery of compensation at the rate of 30,000 on and from March 2015. Now, Lord, the basic case is, Lord, that my client, Lord, has afforded him, Lord, a loan. At the time of execution of, Lord, extending the loan, Lord, it is his case that, Lord, that my client was given possession of one flat with a garage, which is owned by, Lord, the plaintiff, degree holder. Now, Lord, there is a written agreement. The nature of the written agreement is, Lord, which says that I am extending this amount, which is to be adjusted for a 310 Lord days. There's Lord 25 years or something like that. And Lord, it has to be adjusted 2,000 rupees per month.
Adjusted with what?
With the amount that has been Lord given as a loan.
So your occupation charges will be the adjustment.
Occupation, Lord, I have already paid him 6,20,000. As against the 6,20,000,
He gives the land to you.
He gives Lord the
For your
occupancy
that
right
will
of
be
the flat.
adjusted with your possessory. I mean interest. I mean you are possessing for that. That's being adjusted.
And Lord, yes,
for occupation.
For occupation, 2,000 rupees per month.
So as occupation charges without labeling is at rent or whatever.
Now, Lord, your Lordship will kindly come to page 71. Now, Lord, this is Lord, the written agreement between the parties. Now, Lord, this was in June 2006 because Lord, the proximity of date, Lord, I'll also later come. Because my defense was Lord, tenancy.
Obviously, yes. And to avoid that security deposit, you have entered into such a particular
But this was not that gentleman at that point of time, according to the case, he wanted money. My client had the money, and therefore he gave the money with an understanding that the monthly rent will be not adjusted from
That
the
will be a
amount.
loan transaction. It is a mortgage sort of.
And that is the reason his
That is
prayer
the
is.
declaration basically he's seeking.
That is the reason his prayer is that I want recovery of possession. I will pay that 4,02,000. That being the unutilized portion of the loan amount. So, whether this prayer can be at all granted in the because my defense was I am a premises tenant. I'll take your lordship to the written agreement to find out what is the purport of this agreement, because your lordship will find one place where your lordship will find that it can be terminated with a 3 months notice, and 11 month was mentioned in this particular agreement. But in the agreement at page 72, your lordship will find from the and whereas the second paragraph, the party hereto of the second part proposed to let out the said ownership. First part is my client and second part is my learned friend's client, the plaintiff. With a motor garage at Koilash apartment at such and such, proposed to the first party hereto of the first part due to financial stringency, proposed to let out the said ownership flat at Koilash apartment located at such and such to let out the said.
Let out has been used like my lord. Every sentence starts with every phrase starts with a let out.
And let out, tenant, and adjustment, and whereas the last, the party hereto of the second part agreed to one-time full payment of rent of 2,000 rupees. One-time full payment of rent of 2,000 per month for a period of 310 months at a one-time payment of 6,20,000, only which covers 25 years and 10 months, to which the first party agreed to take on the rental basis rupees 2,000 per month for the entire tenancy period. The payment thereof shall be by check and cash in full, that is 6,20,000 inclusive of check number such and such. And, then, the next paragraph, that in consequence thereof, upon the agreed terms and conditions, the entire one-time rent of 2,000 per month for a period of 25 years, 10 months, amounting to such and such, was paid out by cash and check in full as per the above upon taking the possession of the said demised flat. The flat owner shall provide one separate existing meter presently supplying the electricity of the party hereto of the first part. The flat owner shall have no objection in having this and using the said electricity meter, including the room air conditioner, hot water geyser, electric stove for kitchen, chimney, water purifier, etc., shall have to be obtained at the expense of the first party, as the second party shall give full cooperation of having the telephone and other implements as above. This is not an indication of Nani printer's judgment. That intention was not to create a long-term tenancy, not to a licensee. That the tenant herein before mentioned as first party have to install other facilities, kindly omit that portion. That the party of the second part shall alone be liable for payment of all taxes, municipal taxes, existing other levies. Party hereto of the first part shall have not to pay at any time between the period of tenancy ending after 25 years and 10 months. Then, the essential services and then your lordship will come to page 75. The last the sentence, the possession of the demised flat shall be handed over to the party
after the expiry.
After expiry of the period of tenancy, subject to readjustment of rent for 11 months or part thereof. Expiry of the period of tenancy.
Notice of 3
subject to, after 11 months, the second party will have the liberty to terminate this contract by giving a notice of 3 months.
What was held by the trial court?
The learned trial court and as well as the appeal court went into the question whether it is a lease or not, whether it requires a registration or not, whether a one-time rent can be paid or not, and ultimately there was a direction that my client should vacate and hand over possession. That I take your lordship to the reasoning.
Still baffled with the relief sought. Basically, it's a loan agreement.
He seeks a declaration first.
Declaration, after that we understand. After declaration, what declaration? That is where the problem lies.
But that is. That is all that he wanted to say is that I have taken loan. I've given the property as a security. I'm paying
Yes,
back the.
it's a loan transaction and he wants to redeem it
Yes.
by paying the rest of the amount and taking back the property. Basically
Not-
that.
And my contention was
Tenancy.
the agreement spoke about there was a creation of tenancy. You cannot proceed against me without a 6-4 notice, and I am a premises tenant.
How did the court?
Yes, your lordship will kindly,
Let us-
I take your lordship to the appeal court. Lord, at page Lord 5, the decision with reasons.
Yes.
Lord, the plaintiff respondent had asserted, Lord, about Lord, 2 or 3 paragraphs, Lord.
Page 6, the second last sentence.
Lord, about in the middle.
Yes.
Accordingly, this court is first appeal.
This
Do
is
not consider exhibit.
page?
Lord, page 6.
Huh.
Page 6 about middle portion. In view of the pronouncement.
Yes.
Then, Lord, accordingly.
Yes, the
This
bold letter.
court in first appeal do not consider exhibit A and exhibit for the agreement. That is the agreement which I just read out as evidence for want of due registration. 1. Thereafter, my lord, the learned judge proceeds. Then, my lord, the question of lease, how it, my lord, proceeds on the lease, what should be a lease?
George.
The case for mortgage fails on account of non-registration. That is, my lord, the learned judge holds. Then comes, my lord, the rent receipt. Then the learned judge says that there is no monthly rent receipt. Therefore, there is no monthly tenancy. But that your lordship will find, my lord, at page.
Heading is there, rent receipt.
Yes, and at page 8, my lord.
As per the document, the rent was to be adjusted for that with that amount.
I say that the rent was paid in full for a particular period, adjusted 2,000 rupees per month. It was never a case of, my lord, a license that my lord, the learned judge made out.
And page 6, is this a finding? The case for mortgage fails on account of non-registration?
Yes, yes, that is the finding because they took a plea of, my lord, the plaintiff took a plea.
If it's not a mortgage, then it's a monthly tenancy.
That is not my case, and the learned judge was not dwelling on, my lord, the lease, mortgage, non-registration of a document without going into the pith and substance of, my lord, what the recital of the agreement speaks about. Then, Lord, there was a previous, Lord, a notice given under 6(4), which was abandoned by the subsequent notice given.
Eviction has also been directed upon their paying that amount.
Lord, your lordship will kindly come to, Lord. That is trial court.
Trial court, yes. That pays no detail.
Plaintiff is directed to pay a sum of 4,02,000 to the defendant directly or through bank, and in favor of within 1 month from the date, and directed to deliver vacant peaceful possession of the suit property to the plaintiff within 3 months therefrom, failing which the plaintiff is at liberty to put the decree.
Agreement dated 1st of June 2006 is that?
That is the agreement. That is the only agreement.
Order. The present second appeal will be the present second appeal is admitted on the following substantial questions of law. 1. Whether the learned appellate judge, in the teeth of his finding that the case for mortgage as made out by the plaintiff fails on account of non-registration, proceeded to affirm the decree of declaration to the effect that the transaction between the parties was a loan transaction / mortgage. Number 2, whether the learned courts below substantially erred in law in refusing to look at the agreement dated June 1, 2006 for want of due registration, in view of a monthly tenancy agreement under the Rent Control Act, that is the West Bengal Premises Tenancy Act 1997, not being registrable, not being compulsorily registrable. 3. whether both the courts below substantially erred in law in misinterpreting the clear terms of the agreement in question, comma, which unerringly indicates that the same is a tenancy agreement, and passing a decree of eviction without a prior notice under section 6 within bracket 4 of the 1997 Act, and or without satisfaction of any of the grounds for eviction under the said Act. Well, is there any stay application?
Not there is a stay application. So there's CN1.
না আচ্ছা আরেকটা গ্রাউন্ড অ্যাড করে দিন তো whether একটা গ্রাউন্ড অ্যাড হবে whether in view of the agreement in question clearly providing that the amount initially paid by the defendant stroke appellant would be adjusted with the rent payable for the suit property, comma, the learned appellate judge, first appellate judge erred in law in disbelieving the case of tenancy on the ground of non-production of rent receipts by the appellant. Ever. Yes.
There is a title execution 1 of 2020.
Mr. Banerjee, what do you say to the state?
They're occupying 1,536 square feet flat along with a garage, my lord.
The amount they paid is to be adjusted
Now, not the trial
till
court, while granting-
years to come.
The lower appellate court, not while granting stay, has not imposed condition of payment of rupees 20 in 2021.
Rupees?
20 per square feet.
What does it come to?
It comes to not more than 30,000, not around
18,900.
Can't be 15,536 square feet.
But
plus
did they pay that amount?
They have paid a lesser amount, my lord, didn't pay the entire amount. They paid around 19,000 and odd per month.
Is 102
For
not
last-
a stay
last one.
application. The challans are there.
Till the judgment they have paid. Now, my lord, that is a lesser amount. Because 1,536 square feet.
You did not take any objection to that.
They have not filed the application for.
Why are you
stay.
showing him?
No, not him, my lord, not him. But the
He has a
settlement-
slim chance now in any event.
Slimmer chance than
Yes.
before.
So what was the amount paid in the appellate court? Will grant
21, it was 20 rupees 20 per square feet, my lord.
20 per square feet. You are bad in calculation. What is the square feet? How do you know?
1,536 as per the agreement. 1,536
Calculate and tell us what is.
30,720.
What is the location?
32,000.
Beleghat, which
It's around 33,350, my lord. At the rate of 100.
Agreement to area pe likho tha baba.
Agreement আছে তো area.
the area of the flat? What is the area of the flat?
1,536 square feet.
Where do you get that?
In the agreement, my lord.
Oh, yes.
Page
yes.
2
Let
of the
us,
agreement.
let us see that.
1,536 plus 120 square feet.
1536. What to calculate for us? You won't calculate. Very bad in that.
3 bedrooms, 1 kitchen, and 120 square feet garage.
What does it come to the amount?
35,000. No, only 33,070.
No, just calculate in a calculator in your phone.
1,536 plus 120
Both of you do that.
into
At page 102, we have calculated
33,120.
33,
120.
And what have you calculated, Mr. Mukherjee?
No, that is at page 102. Lord, they have calculating on the basis of blood the super built up area. We have calculated on the basis of blood the carpet area 946 square feet. And blood
From where
into
they are getting
20. And
But this 18,920 was being paid all along.
Yes, and
This is
without
the
the demand.
So
And they
you
are
have not
paying on the
objected.
Basis of blood. All
It
through
can't be, but
they
the
are paying.
direction was rupees 20 per square feet.
What can't be? It has
They are
been.
paying not the
Been
owners
paid.
association.
That is it. They have paid that amount throughout. We have accepted the challenge.
And the owners association, I'm paying. blood
Because
the
they've withdrawn that
maintenance
amount
The
also.
order, the order doesn't say they will pay for only the carpet area.
We can only see, Mr. Banerjee, whatever has been paid till the date of the impugned judgment. Impugned judgment was passed on
charge.
last September only. If that is the amount paid by them,
And
80,
once is not the order.
but that was not complied with. You did not raise any demur.
I had a copy there.
20 per square feet, but the quantum is not fixed.
No.
Quantum as per the agreement.
They have calculated as per my lord.
They have calculated, paid, you have accepted without any demur. So rupees 20 has to be calculated as.
Fix the amount. Kindly do not make it rupees 20. Kindly fix the amount, my lord. That is my prayer.
We have to do that. 18,920, that will be the amount, whatever they have paid.
That is their
You
calculation.
can increase it by 180
I am
rupees.
staying in the same property, paying rent of 22,000. There are other agreements also. I will disclose by way of an affidavit. I will disclose by way of affidavit
No,
the
but
same
they
premises.
have paid an amount, substantial amount to you. As per the agreement, your agreement, both of you rely on that. As per that agreement, that the adjustment is to continue for years to come.
And that is a decree, Lord.
So this is my license agreement of the same premises. But
As
I
per
am
the
paying-
decree, you have to pay. Decree, you have to pay for getting version.
the balance amount.
20,000 will be.
But I am paying 22,000 per month. This is the license agreement of my.
You are paying that you have chosen to pay.
So that is the going rate of the same building, my lord. This is the same
What are you
building.
paying? 20?
I am paying 22,000.
Will direct you to pay 22,000. You are appearing, Mr. Mukherjee, it should have been more. We are being very lenient on that.
But
22,000 without a garage. Same area, one
paying the maintenance charges, Lord, that is not for per month 4,090 at page 103. That is not my client is paying. So, Lord, that 22, if your lordship says so, Lord, that will include the maintenance. Lord, 4,090, Lord, each month we are paying, Lord, on behalf of the owner.
Date of judgment.
Date of judgment is it? March, September.
Pay them 20,000. Learned counsel, learned senior counsel for the appellant. No. Can 1 of 2024 order to have. Since the appeal has been admitted, since the second appeal has been admitted on substantial questions of law, comma, it is evident that a strong prima facie case for hearing the appeal on merits have already been made out. Full stop. Next para, learned counsel appearing for the plaintiff stroke respondent contends that the plaintiff stroke respondent is having to pay rupees 22,000 per month for a similar property as the suit premises in the same building. In the same building to the tune of rupees 22,000 per month. Full stop. Next para. However, comma, learned senior counsel appearing for the
adjoining building.
not in the same building, in an adjoining building. Full stop. Next para. It is further pointed out that the learned first appellate judge, comma, while granting stay, had directed the appellant to pay occupation charges at the rate of rupees 20 per square feet, which comes to around rupees 33,120 per month. Who's up next para? Learned senior counsel appearing for the appellant stroke petitioner controverts the submissions of the respondent and places reliance on the challans annexed to the stay application filed in the present appeal, which go on to show that an amount of rupees 18,920 18,920 per month was being paid as occupation charges upon a calculation of the amount of rupees 20 per square feet in terms of the appellate court's order. It is further submitted that no demur was raised at any point of time to the plaintiff respondent to such amount being paid, and as such, comma, the respondent cannot resile from such position and seek a higher quantum as occupation charges. Push up that apart, comma, learned senior counsel points out that the appellant is having to pay maintenance charges to the tune of rupees 4,090. This is per month or
per month?
Yes, 4,090 per month for residing at the said flat to the apartment owners association of the said building, and as such, comma, the said amount also is also required to be taken into consideration while fixing occupation charges. Full stop. Upon hearing learned counsel for the parties, comma, we find that an amount of rupees 18,920 was being paid consistently during the pendency of the appeal. Full stop. Thus keeping on balance the said amount with the fact that the appellant is paying an amount of rupees 22,000 per month for a similar for an apparently similar premises,
Maintenance of 4,000. Plus maintenance.
including maintenance,
No, not including, my lord.
excluding maintenance
Of 4,000.
in an adjoining building, comma, we fix the occupation charges to be 20,000 per month for grant of stay. Full stop. Accordingly, can 1 of 2024 is allowed, comma, thereby granting stay of all further proceedings in
Article execution 1 of 2020.
That is that.
Acha, in title execution case number 1 of 2020 pending before the learned civil judge junior division at single junior division, or there are one civil judge junior division at Shialda. What is the district? You have written Kolkata.
Shialda.
No, district north or south?
Civil judge senior.
North or south? It can be both. South judgment. Comma district south 24 Parganas till disposal of the appeal subject to the appellant paying occupation charges at the rate of rupees 20,000 per month to the respondent, furnish your bank account by way of direct online bank transfer to the respondent's account, comma the particulars of which shall be furnished by the learned advocate on record for the respondent to his counterpart appearing, his or her, his counterpart appearing for the appellant by the end of this week. Full stop. Next para. The first of such current payments shall be made for the month of March 2025 within on or before March 31, 2025, and thereafter for each current month by the end of the said month. Full stop. Next para. The arrear occupation charges from the month of the impugned decree of the appellate court till February 2025 shall be paid by 2 equal monthly installments, comma the first of which shall be payable by March 31, 2025 and the next by April 30, 2025. Full stop. In default of any of the above payments, comma either current or arrear, comma the stay granted above shall stand automatically vacated without further reference to the court.
Kindly expedite the appeal. I shall
Yes,
put in
you shall prepare.
I shall prepare the paper book and put in the.
Very well. On the prayer of the respondent, comma, now in view of the appearance of the respondent through his learned advocate, comma, service of notice of appeal on the respondent is dispensed with. Full stop. On the prayer of learned counsel for the learned senior counsel for the respondent, comma,
Not yet.
you are not confirmed. We are, I'm confusing everything. I'm sorry, very sorry. Learned counsel for the plaintiff respondent, comma, the trial court records shall be brought by special messenger at the cost of the respondent, comma, to be deposited within a week from date. Full stop. Upon the records arriving before this court, comma, examined and being found to be complete, comma, a notice of arrival of the records shall be served on the learned advocate on record for the respondent. Full stop. The respondent shall prepare and file the requisite number of informal paper books without comparing with the records within 4 weeks after such notice being served. Full stop. Next para. Liberty to the parties to mention the appeal for inclusion in the list before the appropriate learned single judge having a determination to hear such appeals. After this, same is ready for hearing. Thank you.
Since no affidavit is used, so far as state
After line add করে দেবেন, since no affidavits have been invited, comma, it is deemed that none of the allegations made in the stay application are admitted by the respondent.
না ওটা আমরা ফার্নিশ করে দাও by letter
bank account.
My lord, for the appellant, my lord, I beg to pray for an adjournment, my lord. We are being led by Mr. Kollul Basu. He has had to go to the hospital to admit his mother, my lord. She has
admit his mother?
Mother, my lord. He
What happened?
Fallen ill, my lord, due to some liver issues. So, my lord, he is not in court, my lord.
What should you do?
That is the thing. And my lord, another thing is that, my lord, on the last occasion, my lord had directed the parties to exchange their documents, my lord. They have, my lord, sent over email, my lord, 7 deeds. My lord, we, on the other hand, have not been able to get hold of all the deeds, my lord. They are coming from Durgapur. My lord, 7 days, if my lord would accommodate.
The appeal has not been admitted as yet.
As yet, no.
Then grant adjournment. What is the
7 days. But if on 25, my lord keeps, then it would be
25th of March.
March, my lord, Monday.
It's a Tuesday. 25th.
25th
of March is a Tuesday.
25th March is a Tuesday. We don't have any difficulties with either Tuesdays or
25th of March, my lord. If my
25th
lord.
of March. Very well. On the prayer of the appellant, let the matter stand adjourned till March 25, 2025. We're not adding anything because you exchanged whatever you had.
In the meantime, my lord, he can give us the copies of the deeds.
He will. That's why he's
I'll
paying for
supply the Great.
Thank you.
Item number 25.
Lord, item 25, my lord, I'm appearing for the appellant in this matter.
Right.
Lord, your lordship takes the impugned order.
There is no caveat in the matter.
There is no caveat in the matter. Lord, this is an appeal against an order passed.
Wait a second. The office was to give a report as to whether the defects
there were some defects which were
yes, those were
pointed out.
directed to be cured. Office was to give a report. Yes, report is given. Sorry, what is the matter?
If your lordship takes up the impugned order, my lord, it's an order dated-
Yes.
It's an order dated 8th of January, my lord, 2025. My lord, the dispute is this, my lord, I'll briefly indicate. My lord, it was a loan agreement, my lord, which was granted by the appellant to the respondents. My lord, the respondents, after making few payments.
First, tell us what is the impugned order? Section 8 rejection.
Section 8 not rejected. They had filed an application, which is the nomenclature was 151, but it was an order, my lord, of mandatory injunction directing me, my lord, to return back the possession of the vehicle. My lord, that order is under challenge.
That's why you have.
That's why, my lord, I have
appealable.
yes, ma'am. Now, my lord,
please now give us.
My lord, it's an loan agreement which was executed in favor of the respondents, under which, my lord, the respondents were supposed to make monthly installment payments. My lord, under the loan agreement, now this was to purchase a particular vehicle. It's a hire purchase agreement. My lord, the loan was supposed to be paid every month by way of an installments. Few installments paid, they have, my lord, thereafter defaulted. My lord, we have given them notice asking them to cure the default. My lord, wherein, my lord, there was a breach, admittedly a breach on their part. In exercise of my rights under the loan agreement, there's a specific clause under the loan agreement which gives me the right to repossess the vehicle. So I give him a notice and I ask him that please make the payment. Otherwise, I have the right to repossess the vehicle as per the agreement, my lord, which I admittedly do. But in the meantime, when they contemplate my action of repayment, they file a civil suit before the learned city civil court, my lord, and obtain an order of injunction. May I, my lord, just my lord, point out the first order.
We have not taken any measure under 13.4.
Well, not
This
13,
is not a 13.4.
not a 13.4 case. But if your lordship takes up one order, my lord, of my stay application at page 42. But the suit was filed on 4th of December 2024, and right on the next page is they move an order, move an application under Order 39, Rule 1 and 2. Lord, the third paragraph, I'll straight away, my lord, read from the fourth last line. Let there be an ad interim order of temporary injunction. If
yes, let there be
restraining the defendant and his men agents from taking possession of the vehicle bearing registration number so and so without due process of law till the next date fixed, subject to, my lord, your lordships will kindly note, payment of regular my lord, monthly installments. So, my lord, this order of injunction, my lord, was also subject to the condition that he continues to make the payments, my lord, under the loan agreement. My lord, he does not. My lord, he does not make
due process of law is also there. You just take the vehicle by musclemen.
No, the contract gives me right, my lord. I'll just indicate. The contract gives me right, my lord.
But the order puts a rider on that without due process of law.
But the due process have been carried out, my lord. There is no complaint.
That your men.
There are some RBI, my lord, guidelines which is there, my lord. My lord, I'm not carrying a copy of the RBI guidelines.
What does it say?
My lord, he has to be notified. He has to be notified that on so and so date, you please hand over the vehicle, failing which will be compelled to go and take the vehicle from. But your lordships will also consider the situation where he does not, but he at one point, at one hand.
That was already the situation when this injunction order was passed.
My lord, this order was passed, my lord, it's an ex parte order, my lord, on complete misrepresentation.
It's equally binding. Unless you file for vacating.
Now, what has happened in the meantime?
Flout that order. This is given a premium, then, I mean.
I'll just indicate, my lord, thereafter what happened.
Orders of court, no.
But thereafter what has happened, my lord?
In the teeth of this order, you yourself decide that the EMI has not been paid and you yourself take possession.
My lord, all these, my lord.
Should have taken a leave from the court.
All, my lord, with deepest of respect, my lord, all these actions, my lord, my lord, your lordships will consider, my lord, these are borrowers, my lord, who take, my lord, even the banks, my lord, for a public, my lord, for a right.
We
Lord, a
appreciate
public,
fully. Banks have full right of recovery, but this is not the method.
Lord,
I mean, this is not a moral lecture to you. I mean, you
I
recover in
appreciate-
whatever manner,
appreciate.
unless it's my vehicle.
No.
But otherwise, court says by a specific temporary ad interim injunction order, without due process of law, you cannot recover. And then you just go there, take the vehicle off. And court has directed you to put it back to the person.
Put it back, my lord, ignoring the fact, my lord, ignoring the fact, my lord, this is where the difficulty is. Because of this pending suit, which has been filed, that which they are entitled to, my lord, I am unable to, my lord, invoke the arbitration clause and proceed. Now, I filed an application under Section 8, my lord, for referring.
You restore the possession, then you will restore the possession immediately.
Restoration has been done because, my lord, there was already
Will direct
an
the
order.
learned trial judge will not interfere, but will direct
But
the
we
learned,
have filed-
request the learned trial judge to dispose of the 5/8 application first before proceeding, before taking up any further matter.
In fact, right after this order, my lord, was the 8th of January order, wherein we had filed an application under Section 8 requesting the learned trial court that please refer this dispute because all these disputes can be
No,
adjudicated.
no, we'll definitely.
That is, my lord, that is my respectful submission.
Will
Lord.
definitely will not interfere with the order, but will definitely direct the learned trial judge to take up the Section 8 application first.
Very well, my
We'll do that. The present appeal has been preferred against an order passed on the basis of an application captioned as one under Section 151 of the Code of Civil Procedure, but substantially for mandatory injunction within the contemplation of Order 39, Rules 1 and 2 of the Code of Civil Procedure. Full stop, next para. The brief facts of the case are that the plaintiff stroke respondent obtained an order of ad interim of ex parte ad interim injunction in connection with a suit filed in respect of a vehicle, comma, which was taken on hire purchase from the present appellant, comma, the lender. Full stop. By way of the ad interim injunction, comma, the learned trial judge had restrained the defendant stroke appellant and its men and agents from taking possession of the vehicle in question without due process of law till the next date fixed, comma, subject to payment of regular EMI. Full stop, next para. Learned counsel for the appellant submits that in view of the failure of the plaintiff stroke respondent to pay the said EMIs, comma, by adhering to the governing guidelines of the Reserve Bank of India, comma, the appellant took possession of the vehicle from the respondent. Full stop, next para. However, comma, by the impugned order, comma, the learned trial judge, comma, without adverting to such facets of the matter, comma, granted a blanket direction on the appellant to restore the possession of the suit vehicle within 7 days to the respondent. Full stop, next para. Upon hearing learned counsel for the appellant and on a careful perusal of the ad interim order of injunction dated December 5, 2024, passed in connection with the title suit from which the present appeal arises, comma,
the present appeal arises out of also the order dated, my lord, 8th of January, my lord, 2025, where my lord, on that day I was asked to, my lord, on an application under 151, I was asked to, my lord, return back the vehicle.
No, no, your appeal arises only from the January 8th order.
Yes, January.
We are saying the same suit from which that appeal arises. Comma, we find that by such ex parte ad interim order, comma, not only was the appellant restrained from taking possession of the vehicle, comma, there were two other components to the said order. First, comma, the same was subject to payment of regular EMI, and we do not find anything on record to indicate that the appellant placed sufficient documents to satisfy the learned trial judge as to non-payment of EMIs after the passing of the ad interim order on December 5, 2024. The second component was that the repossession, comma, if any, comma, was to be in due process of law. In the present case, comma, the learned trial judge recorded dissatisfaction on the issue of due process of law having been followed, full stop. As such, comma, we do not find any reason to interfere with such exercise of discretion by the learned trial judge by substituting our own views in the matter. Full stop, next para. Since the repossession was apparently in violation of the ex parte ad interim injunction order, comma, the learned trial judge was justified in directing restoration of the vehicle to the respondent. Full stop, next para. Hence, comma, there is no scope of interference with the impugned order. Full stop, next para. Accordingly, FMAT 26 of 2025 is dismissed under Order 41, Rule 11 of the Code of Civil Procedure, comma, consequentially, the connected application bearing Can 1 of 2025 also stands dismissed. Full stop, next para. However, comma, in view of an application under sections 5 and 8 of the Arbitration and Conciliation Act 1996 being pending before the learned trial judge at the behest of the defendant stroke appellant, comma, for substantial justice, comma, the said application ought to be decided first by the learned trial judge, comma, before proceeding with further with the suit or connected interlocutory applications. First of it is expected that the said application under sections 5 and 8 shall be disposed of by the learned trial judge as expeditiously as possible, comma, preferably within 4 weeks from the date of communication of this order to the learned trial judge.
May I make, my lord, one additional prayer, my lord? I have
Yes.
also filed an application under Order 39, Rule 4 for vacating the order, but this order should not, my lord, not have any impact on my pending application, because there I'll be entitled to, my lord, bring all these documents on record, my lord.
We further clarify that none of the above observations have been rendered. We further clarify that the above observations are tentative, comma, only for the purpose of deciding the issue at hand and shall not be conclusive or binding on the learned trial judge at any further stage of the injunction application or the suit and stroke or any connected interlocutory applications.
I'm deeply over.
Thank you. ওদের অর্ডার ভায়োলেট করে নিয়ে নিয়েছে এটা শুনে দিতে হবে আগে সে ম্যান্ডেট অফ ল
26, my lord, I am appearing on behalf of the appellant, my lord.
Right.
My lord.
Out of time, you have filed a section 5?
Yes, yes, my lord, already I have filed an application. Under
Section 5 has been allowed?
No, my lord.
Appearing for the first time?
First time.
You
I have
directed to
served.
serve and come back?
My lord, already I have served.
Without direction of court, no meaning. If they appeared, we would have taken up the matter. Otherwise, the appellant shall serve copies of Can 1 of 2025, comma, Can 2 of 2025, and the memorandum of the appeal on the respondents, on the who are the pro forma respondents?
My lord, they are also the defendant.
They were
Before
defendant. All should be served, or your relief is only against
only against the
1 to 5?
The principal.
Acha, on the respondent numbers 1 to 5, indicating that the applications shall be listed for hearing on March 24, 2025, when an affidavit of service to that effect shall be filed by the appellant. Full stop. Service on the pro forma respondent numbers 6 to 19 is dispensed with for the present.
Great.
Serve copies of both the applications and the memo and come back so that
Yes,
you can
yes.
take up the section 5 and immediately.
Yes, one.
Yes.
But item number 27, I beg to appear on behalf of the respondent. Before my
I'm the
learned
appellant.
friend starts, my lord, I have a cross appeal. My lord, I have not filed the appeal on the first instance. It was filed by my learned friend because he was a respondent in that appellate court. Before
You
the
have filed an
second
independent appeal with a number
with a number
or a
that
cross
is called-
objection only.
Yes, cross objection in the form of an appeal. My lord, that is not appearing before your lordship.
No, no,
That is
cross
court
objection cannot be in the
78
form
of
of an appeal. It's a COT or
yes, COT, my lord. And
so that is appearing before us today.
not appearing before us. So let that also be
That has to be taken up
That-
together, Mr.
Yes, that has to be taken up together.
Give the number on a slip of paper.
COT
My point
78.
is,
No, just write it on a slip of. Your point is?
my point is absolutely different. Only two grounds: decree for eviction, past, subletting and requirement. This is a order of remand by the
Oh.
first appellate court. That is why it's first miscellaneous appeal.
Why? What is the ground of your appeal? I mean, the appeal court itself could have decided.
Appeal court decided requirement in my favor.
Then?
But said, I intend that for the adjudication of subletting, it should be remanded back. But the observation is, to the effect of requirement, the
They
judgment.
had to file this cross appeal, cross objection.
Yes, one of our
You
point
had
has
to
not
file
been.
it. Yes, yes.
We had to file. That's fine.
Because otherwise they have a clear-cut case.
Yes,
We
they have a
would,
clear-cut case.
we
They will
wouldn't
go with
even,
it.
we wouldn't even
One
have
of two grounds.
fix
One
it for
was-
hearing. We'll at the
we
admission
had
stage we'll
to,
allow
yes.
it.
That's why we had to.
Very well.
actually.
Your
The
cross
reasonable
objection has
requirement
it becomes
ground
more
was-
important than his.
But
Yes.
that has not been served upon us also.
Please do serve a
We'll
copy.
serve it today itself.
Serve whatever you have to serve and Acha, learned counsel for appearing for the respondent submits that there is a cross objection pending at the behest of the respondents. Full stop. Accordingly, let the said cross objection along with connected applications, if any, be listed along with the present appeal and be listed together on March 18, 2025. Please give the number of
Let it be 2 days after, because from 12th to 16th I am not in Calcutta.
18th.
I have a senior, Rupak Ghosh is leading me in this matter, so I need to actually.
So when should you keep it? Tell us.
19 or 20, whatever.
19th will be
One
it. 18th na kore 19th kore.
Yes.
19th. 20th we take up hearing
No
matters.
problem.
You have any
Only-
difficulty on that? Any application in connection with the cross objection? Give
No,
that
no.
number also.
No. We
Any
don't
cross
have.
objection that has been filed for our court, this court.
Yes, that has been.
তাহলে ওটা দিয়ে দেবেন।
লিস্টে আছে আলাদা
It is not appearing in the list.
our can is there in the list.
Your can is there.
Yes.
His cross objection.
Great.
Please.
Thank you.
Number 28. In this matter, I am for the petitioner.
Yes, please.
The petitioner is the lawful owner of the land. This
First of all, what is the defect? You have to check. Up.
lordship,
The defect has been removed. Yes, what is the appeal against? Sorry.
appeal against the Lanit trial court failed to consider delay in granting ad interim injunction lead to creation of multiple third-party interest in the suit property, complicating the legal proceedings and causing irreparable loss, harm to the petitioner. The fraudulent transfer have already been created, a cloud over the petitioner's title.
You're reading from that notes.
Yes, Your Lordship, I would like to
How long are you
submit
practicing?
this, 10 years.
Then why are you reading from the notes? It has to be extempore.
Your Lordship, this is
What
the
is this?
supplementary affidavit.
Wait, there is no caveat to the injunction application.
No caveat is there.
Let us first admit the appeal. Let us decide whether we should admit the appeal. Yes.
Lordship, the petitioner is the lawful owner.
The suit is for what?
Suit is for declaration of injunction.
Declaration of your title and injunction.
Title and injunction.
What is the ad interim injunction refused? Let us see. Where is your injunction application which you filed in the court below? Let us see that. It has been must have been annexed here.
Yes, Lord. Page.
Which page?
And last page.
Plainly have annexed. The injunction application must be annexed on which the order was passed.
Actually,
Yes, page 123 is the prayer. না না দেওয়া উচিত ছিল না একদম। ফালতু কথা বলেছে, বলছে যে সিম্পলি বলে দিল যে যখন করবে তখন দেখা যাবে না ওটা ডিউরিং পেন্ডিং দেয়ার ইজ এনি অ্যাক্ট ইট উইল বি in view of questions of both fact and law being involved, comma, we find that a prima facie case for admission of the appeal has been made out. So accordingly, the appeal is admitted and will be heard on the grounds as taken in the memorandum of appeal. So next para, leave is granted to the petitioner to file supplementary affidavit, which is kept on record. Full stop. Next para, we find from the impugned order that the learned trial judge refused to grant ad interim injunction, comma, despite the plaintiff stroke petitioner having made out a prima facie case for grant of injunction, comma, inter alia on the ground that if there is any change in nature and character of the property or creation of third party interest, comma, the same shall be within double inverted affected double inverted clause by the decree or order of the suit. Full stop. Next para, apparently, comma, the learned trial judge meant that such transfer or change of nature and character will abide by the outcome of the suit. Full stop. However, comma, the learned trial judge failed to consider that at the ex parte ad interim stage, comma, the court has to proceed on the premise that the allegations made in the injunction application are sacrosanct and to consider only whether an order of injunction can be granted on such pleadings. Full stop. That apart, comma, the approach of the learned trial judge to the effect that any change in nature and character or third party interest, if created, comma, would abide by the outcome of the suit, comma, is erroneous inasmuch as such change in nature and character and or transfer in favor of third parties may create irreversible rights and give rise to unnecessary multiplicity of proceedings. Full stop. Accordingly, accordingly, the respondents shall remain restrained by an order of injunction from changing the nature and character of the suit property in any manner whatsoever, and stroke or from selling, transferring, alienating on and or creating any third party interest in respect of the suit property during pendency of Can 1 of 2024. Full stop. The petitioner shall serve copies of the application on the respondents stroke opposite parties along with a copy of the supplementary affidavit filed today, indicating that the application shall next be listed for hearing under the appropriate heading in the monthly list of April 2025. Full stop. The appellant shall file an affidavit of service to that effect on the returnable date.
Almost identical time as yesterday's one.
Peculiar. You always get your
Almost
chance.
identical.
Today you have 4 minutes left. Yesterday it was 3 minutes.
3 minutes
left.
Yes.
You have a knack of these things.
But it's not in my control. Your lordship's court.
My control, our control. You are doing matters throughout the day, and we are. And the size is similar to the previous day's matter also.
No.
And he is there on the other side. No, we'll take up.
No, he's not.
You're not on this. What is the appeal against?
If your lordship kindly takes a look at, I'll take your lordship to the order impugned in a bit, my lord. Kindly takes a look at page 352. Your lordships had the occasion of considering an appeal from an order dismissing order 39 rules 1 and 2 application. My lord, it is an appeal now from an order dismissing order 40 application because 39(1)(2) was dismissed. So your lordships were pleased to set aside that 39 rule 1 and 2 at order and granted injunction till the disposal of the suit. So there is really nothing more than this order. Kindly seize this order, my lord.
Let us see the impugned order here.
Right.
No, by that order, we had granted injunction.
Yes.
We reversed the refusal and granted injunction.
Granted injunction to the disposal of the suit.
But the present rejection is on the ground that there was a refusal of injunction.
Refusal of the injunction.
Let us see the impugned order. Yes. Let us see the memo.
But this is order number 41 dated 19th of December 2020.
What has been quoted here? This is the refusal of injunction by the court below. The italics.
Yes.
Uh,
Yes. The quotation portion from the middle is the.
But order 40 has to be on a higher footing.
I understand, but kindly seize the
You
reasoning.
can admit the appeal, but can't
That is
receiver
exactly why we had tried to serve and come back, because receiver expert, yes,
will
that
admit
is,
and directly
I
to serve
understand.
will
I
fix a short date.
I understand.
The primary premise of the impugned order was that the primary premise of the impugned order, comma, refusing to appoint a receiver under Order 40, Rule 1 of the Code of Civil Procedure was that previously the learned trial judge had refused injunction to the plaintiff stroke appellant. However, comma, the learned trial judge overlooked the fact that such refusal was reversed in appeal
No,
by
my lord,
this.
my lord, the appeal reversal had taken place after that. So this
After this order.
After this order.
আচ্ছা without taking into consideration না ওখানে ফুলস্টপ without যেখানে বলুন তার আগে ফুলস্টপ দিয়ে দাও however comma in view of such refusal of injunction having been reversed in appeal subsequent to the present impugned order and injunction having been granted by this court in a different appeal comma the very premise of the refusal to appoint receiver in the impugned order becomes questionable. Full stop. Accordingly, the appeal is admitted on the above grounds and on the other grounds taken in the memorandum of appeal. Full stop. Next para. However, comma at this stage, comma it would, comma in our opinion, comma be premature to appoint a receiver without hearing the other side. Full stop. Accordingly, the appellant shall serve copies of what is the CAN number? CAN 1 of 2025 on the respondents, indicating that the application shall be listed for hearing on March 24, 2025, when an affidavit of service shall be filed by the appellant.
Could it be any day before the 22nd or after the 31st? My advocate on record would not be there during that.
So then, তাহলে returnable date টা করে দাও ইয়ে না করে দাও April 2, 2025, 2nd April. Yes.
That's item number 30 and 31. Well, just praying for consent.
I'm for the appellant, my lord.
30, 31 board দেখে দিন, call করে দিন. Yes.
I'm for the appellant. Mr. Chatterjee is on the other side.
What are you asking for?
My lord, they're asking for Tuesday.
What are you asking?
I'm asking for moving the appeal, but they're requesting for Tuesday. I have no difficulty if it is taken up on Tuesday.
Then when should you keep it?
Tuesday, my lord.
Tuesday. On the prayer of?
Both joint prayer.
You are for the respondent.
Respondent caveat.
He doesn't have a right of hearing.
So he's
On the prayer of the respondents, that the matter stand adjourned till March 18, 2025. 30, 31 একসঙ্গে। 30, 31 দুটো বোর্ডে দেখান।
ঠিক আছে।
Wednesday is 19th.
19th.
The returnable date Pritam 19th.
Affidavit of service.
March 19, 2020.
Affidavit of service.
Affidavits of service filed today be kept on record. ওটা 19th March কিন্তু returnable. অনিন্দিতা আপনাকে বলছি। ও দেবেন লিস্ট আপনি দেবেন।
তো এর মধ্যে